Hello, everybody. Welcome. Welcome. Hello. Okay, welcome. Thank you for coming. Hello again. Hello, everybody. Hello. Welcome, welcome. Hello, everyone. Thank you for joining me. Hello. Good evening. Thank you for coming tonight. Appreciate that. Hello. Hi. Hello, everybody. Welcome. Yes. Hello. Yes, I'm trying to kind of go back into, yes, we're going to be going, Jilly Bean, we're going to be going through the Constitution tonight. This was requested and something that I typically have done before. It's going to be a short live. Well, I'm going to go not only through the Constitution, but also explain the sections of the Constitution that have been replaced by different amendments. I will also be going through some very important U.S. Supreme Court cases when it comes to amendments, so you can kind of figure out which court cases are most important. So, oh, good. Love to hear that. Love to hear that. Oh, your favorite bedtime story. Oh, excellent. Oh, I love to hear that. Yes. Welcome, Amos. Welcome. Thank you for being here. I will be walking through the Constitution tonight, going through the changes that have been made, the amendments, those key U.S. Supreme Court cases, and so on, and kind of explaining, how we go through things here. So this is a copy from the National Constitution Center, which is an amazing place in Philadelphia, and they do really fantastic work when it comes to the Constitution. But this book itself, you can find online. It's Applewood's Books, and this copy that I have here, I did get from the Little White House in Key West years ago. So I do like to use this. So I do have lots of different forms of that. Will you go over what Roe versus Wade actually was? I think a lot of people misunderstand it. I have that on my list of things to do on another live. I won't be doing it tonight, but I have here the primary cases, all of our abortion cases here, with the Dobbs case included as well. So this will be one of the lives that I will be doing. Roe versus Wade, the Casey case, Griswold, along with Dobbs. So I do have that kind of on my plan to do. I won't be going through it tonight, just because I'll be going through the Constitution itself tonight, but I absolutely will be doing a live just on all of those equal protection privacy issues out of the privacy rights that came out of all of the abortion cases. So I will be doing that. for sure. But tonight, I really want to walk everyone through the Constitution and the key cases that we have when we're dealing with the Constitution. I think it'd be helpful to go through the Electoral College again, kind of explain how that worked and how things kind of got changed around and so on. So yes, the Library of Congress does a very nice job. I will be adding some additional pieces, case law and so on, some famous cases for the different articles and amendments and so on to just kind of supplement the information. So yes, this particular book you can find. Oh, thank you. Thank you for the roses. This one is online. I did get it myself when I was at the Little White House in Key West. But this, I think this style of book you can find online. It is available. It's Applewood Books. So, but I have a lot of different versions. So you can just kind of find what works for you. I have this one, which has the Declaration of Independence as well as the Constitution included. So this is really helpful. Also, here's another just pocket Constitution, and there's some extra facts in here. And that's helpful. Of course, we have a Spanish version. There is a French version. I left that downstairs, so I don't have that with me, but we have that in Spanish and in French. And then for anyone who just wants it to be just word for word, there's also, they have what we call the bar charts, which is a supplement where they just go through and put it all into kind of a laminated handout. So you can have, it has all of the amendments, all of the language in it, which is very helpful. But you certainly don't need any of this. It's all available online. And any copy of it, I think, is absolutely helpful. There's some great apps, too, that include a lot of different pieces. And so you can kind of look into those as well if you're interested. So lots of great places to have that. And I think it's helpful just so you can understand, what's what. I will be going through this one, and I have notes included in it and highlighted sections just so that, because so many amendments changed so much of the original articles that were set out. So I've just kind of included that here so everyone can really see. Oh, thank you. Thank you so much for that. But I don't think, I think some people may not realize how much we've actually changed in the original Constitution through amendments over time. So I think a lot of people remember, we have the Prohibition Amendment of the 18th Amendment and the 21st Amendment, but there's a lot of things that have changed within the Constitution that needed to change. So several amendments that were passed in order to kind of clean up and fix things to make it better for what we needed at the time. And I think we are also in a position now even that we may have some things that we want to change in the Constitution. It's the oldest written Constitution in the world, and things have changed since the time that it was written. So, of course, we can put a constitutional convention together, and if people are interested. So, I think we'll see another amendment in our lifetime. I think it's possible. I think some things will need to happen. We need to have some. We need to figure out a way to kind of come together again on just anything. We have to kind of start slow, I think, in order to come back together. But I think, yes, they did. My poor hands, I had to. Oh, yes, I'm trying to keep them so that they are not too distracting for people. Term limits, yes. I mean, there's been lots of discussion about term limits, and that would have to go through Congress in order for that to be passed. So we'll see. We had an amendment, the last amendment, the 27th Amendment, was passed in the 90s, but it was actually part of the original set of proposed articles that were the Bill of Rights. We had 12 that were proposed, 10 that were agreed to, hence why we've got the Bill of Rights. But our 27th Amendment is literally the exact same proposed amendment that we had way back in the beginning with James Madison. So it'll be interesting to see. So yes, the Electoral College is a mess. It is an absolute mess, absolute mess. So would love for you to explain these people that are claiming to be sovereign citizens. It's confusing. Yes. Okay. Oh my goodness. Yes. Sovereign citizens stuff is, something that kind of came out and kind of has morphed into several different things. But yeah, that's if you try to use a sovereign citizen defense in court, you're going to have some issues with that. People votes no electoral college. Yeah, I think the electoral college is a mess, and we'll go through it. I'll go through the original format of the electoral college and then how they tried to change it. They knew there were problems, so they did try to change it with that 12th Amendment, but we still haven't really gotten to where we need to be. Yes, new states are included not by amendment, but through the articles. We have to have the procedure set out in the articles, and I believe it's Article 6. It might be Article 5. We'll get there. I sometimes get 5 and 6 mixed up, but yes, we have to go through the article in order to add states. Yes, the Electoral College is important. It really is important. I think the way that it's implemented is, we're struggling. I think a lot of people are struggling with it. So I think it could be better. I think it could be better in our current situation. So yes. Oh, well, thank you. Oh, that's so nice of you to say. Yes, I will be going through the Constitution and reading it, but I will also be adding in the changes that were made, the case law that was done by the U.S. Supreme Court. So it won't just be just word for word. It'll actually be, different pieces of history and so on, because a lot of things have changed since it was originally written. In our amendments, we've got a ton of U.S. Supreme Court cases that have gone through and interpreted those amendments. So I will... Oh, thank you. Oh, thank you, Deborah. I appreciate that. But yeah, we've had a lot of changes that have happened here. So I just kind of want to give everyone an overview, a little bit of going through and talking about what changes have been made, what laws, what SCOTUS cases we have that govern our different amendments and so on. So, Texas. Yeah, Texas is having some, I was just reading a case earlier today on a Texas situation that came up right after the Civil War about, I think it's Texas versus White, if I remember, because, there was a question about whether or not Texas seceded from the Union in order to fight for the South. And there were a lot of debts in question. And ultimately, they held that technically Texas did not secede from the Union because the governor had not approved of that. And of course, that was within the parameters of a debt issue that was going on there after the Civil War. But yeah, they have a very, very fascinating history in Texas. So yes, Texas. I've got a soft spot for Texas. I lived in Texas for several years when I was growing up, when I was a child. So I still have family in Texas. It is a unique place with kind of its own way of looking at things. So yes, and a lot of people, it was very controversial, and I'm planning to kind of put together to kind of go over those cases. Any cases that come out of the 1800s, I try to just not do too many, but I think they're also important. Yes, both of my parents were military. We didn't really move around by the time I came along. They kind of had settled, but yeah, King James Version of the Constitution. Oh my goodness, that's one of the funniest things I've heard tonight. All right, let me go ahead and dive right in. So here we go, the Constitution, and this is from the National Constitution Center, which is in Philadelphia. If you ever get a chance, I highly recommend going and taking a look around there. They do such an incredible job explaining the history and a lot of the information about how all of that went down. Of course, Philadelphia is where our Declaration of Independence was done, and Benjamin Franklin's hometown. So there's a lot of stuff going on in Philadelphia. So let's get started. Let me walk you through. We're going to start going through, and I will, again, give some supplemental information as we go through, just to kind of explain the changes and so on. So let's start at the very beginning, which is our preamble. Now, before I go into the preamble, it is good to note that the U.S. Supreme Court has held that the preamble may not be used in litigation. So this is not a legally binding piece of the Constitution. It's a wonderful introduction. It's a wonderful opening. But legally, if we were to argue constitutional law issues, we can bring it up to just say, hey, this is interesting. But the preamble itself is not binding legal piece of the Constitution. So I think, that's kind of an interesting side note. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution of the United States of America. So this, of course, is a very famous preamble here, kind of setting us up for putting together the government. Now, keep in mind, again, this was coming after the Articles of Confederation had not worked properly. We had a lot of problems with the Articles of Confederation, and the biggest problem was that Congress was so weak that taxes weren't taken in properly, the militia wasn't being paid for, and so with all of those issues, they had to go through and kind of set up a new constitution. So this preamble is really just kind of setting us up for the very first article, which is Article 1, which sets out Congress. And again, because of the problems that came from the Articles of Confederation, Congress was the most important element that they wanted to include in that. So let's go ahead and go through these one piece at a time, and I'll walk you through what's been changed and what's kind of stayed the same, a little bit of history here. So Section 1, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. Very controversial at the time. People were upset because if you had a small state but a large population, maybe you weren't going to be heard as much as the other states. So this is what we call the Great Compromise, when they picked the Senate for 2 senators and then the House of Representatives based off of population. Section 2, the House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. So at the time, of course, our colonies, their state legislatures were so powerful and so important that they really wanted all the power to be kept to them rather than, the commoners. So a lot of what was set up here had to do with the state legislatures. No person shall be a representative who shall not have attained to the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Now, this next section I'm going to take you through, but this was altered, of course, by the 13th and 14th Amendments. So this part of this next section is no longer applicable, although, of course, still a part of Article 1. Representatives and direct taxes shall be apportioned among the several states, which may be included within this union, according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed 3/5 of all other persons. Which, of course, when we passed the 13th Amendment, which abolished slavery, this was no longer usable. So this is not used anymore. And of course, through the 14th Amendment, equal protection as well. And as we now know our indigenous peoples are taxed. And so there are taxes that come in through that now. So this particular section does not apply any further. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3. You can see what's going on there with New Hampshire. They were kind of fighting things out a little bit here at the time. Massachusetts 8, Rhode Island and Providence Plantation 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. So these were the original sets of representatives. When vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. The House of Representatives shall choose their speaker and other officers and shall have the sole power of impeachment. So something interesting to note here, when we had the Articles of Confederation, there was no way for anyone who was in the Congress to leave, even though Congress was so weak. Once you were in until you could find someone to replace you, and nobody wanted to be a part of Congress. So they couldn't find anybody, and so nobody ever showed up. So they had Congress constantly, but nobody came to any of the meetings, which absolutely drove Alexander Hamilton crazy. But that's kind of part of what happened there. So that's why we have these couple of pieces set in here to make sure that if someone wants to leave, you can leave under the Constitution. Section 3. Again, this first sentence is no longer applicable because the 17th Amendment changed how we go about it. So although this is still here, it is not usable because it has been replaced by the 17th Amendment. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof for 6 years, and each senator shall have 1 vote. So chosen by the state legislature thereof is no longer the case. Under the 17th Amendment that was passed, we now have popular elections for our senators. Next, immediately after, they shall be assembled in consequence of the first election. They shall be divided as equally as may be into 3 classes. The seats of senators of the first class shall be vacated at the expiration of the second year, of the second class at the expiration of the 4th year, and of the third class at the expiration of the 6th year, so that 1/3 may be chosen every year. And then again, this portion was replaced by the 17th Amendment, and if vacancies happen by resignation or otherwise, during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. This is no longer applicable because of the 17th Amendment. So that's our first piece here, and that takes us to the next part then of Section 3 under Article 1. No person shall be a senator who shall not have attained the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of the state for which he shall be chosen. The Vice President of the United States shall be the President of the Senate, but shall have no vote unless they be equally divided. The Senate shall choose their other officers and also a president pro tempore in the absence of the vice president, or when he shall exercise the office of the President of the United States. So, and this is just a legal Latin term for temporary position. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Judgment in the cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. So that's Section 3. Now, Section 4. The times, place, and manner of holding elections for the senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations except as to the places of choosing senators. The Congress shall assemble at least once every year, and such meeting shall be, and this portion has been replaced, on the first Monday in December. And we have moved that date through the 20th Amendment to the 3rd of January, unless they shall by law appoint a different day, which they did through the 20th Amendment. Section 5, each house shall be the judge of the elections, returns, and qualifications of its own members, and a majority of each shall constitute a quorum to do business, but a smaller number may adjourn from day to day and may be authorized to compel the attendance of absent members in such manner and under such penalties as each house may provide. Each House may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3 expel a member. Each House shall keep a journal of its proceeding and from time to time publish the same, excepting such parts as may in their judgment require secrecy, and the yeas and nays of the members of either House on any question shall, at the desire of 1/5 of those present, be entered on the journal. Neither House, during the session of Congress, shall, without the consent of the other, adjourn for more than 3 days, nor to any place than that in which the two houses shall be sitting. Again, this was added because we had so many problems with the Articles of Confederation and nobody showing up. Just nobody came. They didn't they didn't come in at all. Section 6. The senators and representatives shall receive a compensation for their services to be ascertained by law and paid out by the Treasury of the United States. They shall, in all cases, except treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses. This is really important too. This is that congressional immunity that a lot of people are talking about. So they do have congressional immunity except for treason, felony, and breach of the peace. They have a privilege outside of that. And in going to and returning from the same, and for any speech or debate in either house, they shall not be questioned in any other place. No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time, and no person holding any office under the United States shall be a member of either house during his continuance in office. So that sets out the first article. And this, of course, is the most complicated of all of the articles. Yes, we'll be getting into each one of the amendments. I will take you through all of those. But I think it's important to remember the Constitution itself are the articles that created the government. So the amendments were added later. Article 7, all bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as on other bills. Every bill which shall have been passed, the House of Representatives and Senate shall, before it become a law, be presented to the President of the United States. If he approves, he shall sign it, but if not, he shall return it with his objections to the House in which it shall have been originated, who shall enter the objections at large on their journal and proceed to reconsider it. If after such reconsideration 2/3 of that House shall agree to pass the bill, it shall be sent together with the objections to the other House, by which it shall likewise be reconsidered, and if approval by 2/3 of the House, it shall become law. But in all such cases, the votes of both houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each house respectively. If any bill shall not be returned by the President within 10 days, Sunday it, unless the Congress by their adjournment prevent its return, in which case it shall not be a law. Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and the House of Representatives, according to the rules and limitations prescribed in the case of a bill. That's Section 7. Now, Section 8 is going to set out those specific duties that Congress is supposed to have. And this is also where we're going to find the Commerce Clause. The Congress shall have the power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. to borrow money on the credit of the United States, to regulate commerce with foreign nations and among the several states and with the Indian tribes. Couple of things. First, we have, this is the Commerce Clause. This is what we refer to legally as the Indian Commerce Clause. So that's kind of a side note here. But whenever we're talking about equal protection and various things, it's because of this piece of Article 1. To establish a uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States, to coin money, regulate the value thereof and a foreign coin, and fix the standard of weights and measures. To provide for the punishment of counterfeiting the securities and current coin of the United States, to establish post offices and post roads, to promote the progress of science and useful arts, by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. So this is our trademark and patent law section. To constitute tribunals inferior to the Supreme Court, to define and punish piracies and felonies committed on the high seas and offenses against the law of nations, to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water, to raise and support armies, but no appropriation of money to use that use shall be for longer term than 2 years, to provide and maintain a navy, to make rules for the government and regulation of the land and naval forces, to provide for calling forth the militia, to execute the laws of the Union. So this is another important piece here, okay? So Congress is in charge of calling forth the militia. Now, we'll see the militia again, of course, within the Second Amendment, but this is saying, that militia everybody's talking about in the Second Amendment is under the authority of Congress. I think some people miss that. To suppress insurrections and repel invasions. So this would be more of like a National Guard type situation when they're talking about the militia within the Constitution. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the apportionment of the officers and the authority of training the militia according to the discipline prescribed by Congress. So we've got the militia. Yes, they do. I think a lot of people do. The militia that everyone's talking about, that's up to Congress. So let's keep that in mind as we go through here. We're almost done with Article 1, and then we will zip through the next pieces. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as may, by cession of a particular state and the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the states in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make all laws which shall be necessary and proper for the carrying into execution the foregoing powers. So this is the necessary and propers clause that is cited all the time as well for congressional authority. And all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Now we go into Section 9, and this is probably the single most controversial section that was written. And we refer to this as the refugee slave or returned slave clause, which is horrendous. It is no longer in place because we have the 13th Amendment, but this is literally written into the Constitution. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation, not exceeding $10 for each person. The privilege of the writ of habeas corpus shall not be suspended unless when cases of rebellion or invasion to the public safety may require it. No bill of attainder or ex post facto law shall be passed. So we cannot file any law that goes retroactively. Yes, we've got a couple of different slave clauses throughout the original articles. I mean, they're just written there. So, if anyone says we can't discuss slavery, I get it, but then that takes the Constitution off the table. I mean, those are the words used. No capitulation or other direct tax shall be laid unless the proportion to the census or enumeration herein before directed to be taken. We changed this with the 16th Amendment. So we've got income tax that came in for the 16th Amendment. No tax or duty shall be laid on articles exported from the state. No preference shall be given by any regulation of the commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. No money shall be drawn from the treasury, but in consequence of appropriations made by law, and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. No title of nobility shall be granted by the United States. This was another huge piece that was put in there, and something that Alexander Hamilton was very against. He had wanted a king. He had thought the king would be most appropriate. Of course, we have a president. And no person holding any office of profit or trust under them shall, without the consent of Congress, accept any of the present emoluments, right, emoluments clause, office or title of any kind, whatever, from any king, prince, or foreign state. Section 10. So this is the last piece of Article 2. No state shall enter into a treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver, coin a tender in payment of debts, pass any bill of attainder ex post facto law or law impairing the obligation of contracts, or grant any title of nobility. No state shall, without the consent of Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, and the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the Treasury, the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded or in such imminent danger as will not admit of delay. So that's Article 1. So there we go. We've got Congress set out. Yes. And again, I think we have a couple of clauses now that make reference to people brought in to the country, as well as our indigenous populations. So let's go into Article 2. Article 2 has been chopped up quite a bit, actually. Article 2 sets out the executive branch, and everything I've highlighted here, as well as here, have been changed. We've got the 12th Amendment that changed this. So this is the Electoral College. We'll go into this. And then we also have this piece over here, which is kind of the order of what happens. How is the bank now legal? We had a lot of case law coming out of the U.S. Supreme Court about how coinage and how banks were supposed to be done. So the bank note, yes. And we have, I think probably the most famous is McCulloch versus Maryland. And that case had to do with McCulloch was like, hey, we're a bank, Congress established us, and so we're going to come into Michigan, or we're going to come into Maryland and do whatever we want. And Maryland said, if you're a bank and you're in Maryland, you need to use our paper and follow our rules. McCulloch said, we're not going to. Congress made us. It went to the U.S. Supreme Court, and the U.S. Supreme Court said, if you're in Maryland and you're a bank, you need to follow Maryland's rules. So that was really the case that established this idea that when we're trying to force something like a bank or something like that into individual states, states have the say. So that case is called McCulloch versus Maryland. Article 2, Section 1, the executive power shall be vested in a president of the United States. He shall hold his office during the term of 4 years, and together with the vice president, chosen for the same term, be elected as follows. Now, this again is how the process was supposed to work. It has been changed over time. Each state shall appoint in such manner as the legislature thereof may direct a number of electors, equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. So this is the original Electoral College and how it works. So let's go through that just so we can see where we're at now compared to where we used to be. The electors shall meet in their respective states and vote by ballot for two persons, of whom one at least shall not be an inhabitant of the same state with themselves. And they shall make a list of all persons voted for and of the numbers of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all of the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the president, if such number be a majority, and of the whole number of the electors appointed. And if there be more than one who have such majority and have equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for president. And if no person have the majority, then from the 5 highest on the list, the said House shall in like manner choose the president. So there was a lot of power given to the House of Representatives. But in choosing the president, the voters shall be taken by the states, and the representation from each state, having one vote, a quorum for this person shall consist of a member or members from 2/3 of the states, and a majority of the states shall be necessary to a choice. In every case, after the choice of the president, the person having the greatest number of votes of the electors shall be the vice president. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot the vice president. So this was a mess. This was a mess because of the 1800 election. Now, the 1800 election was between John Adams and Thomas Jefferson. Of course, we have Aaron Burr coming in as well. So, the controversy was nobody knew how the electors were really supposed to work and how things were supposed to happen. And so Thomas Jefferson won, but the question was, I don't think he actually won. I think the electors just didn't do things correctly. And then Aaron Burr came in as vice president. So Aaron Burr was like, great, I got second place under Jefferson, but, Adams is out and that's fine. Everybody came in and said, well, this is a nightmare. We're never going to have that again. So they changed the Electoral College so that this would never happen again when it came to Jefferson and Adams and Aaron Burr. Now, when we added the 12th Amendment to change that, it was added just a few months before the duel between Alexander Hamilton and Aaron Burr, which of course Hamilton supported Jefferson instead of Burr, and Burr was pretty upset and felt that had cost him the presidency. So this is all about this situation here, that nobody understood how it worked, and that election of 1800 was a mess, and so we had to completely replace the Electoral College, which we did with the 12th Amendment. Can someone tell me what dual federalism is? Oh, I'm not sure what dual federalism is. Federalism is this idea of federal versus states' rights. That's what federalism is defined as. But 2 types of federalism, I'm not sure what that is. Yes. So, again, this was replaced by the 12th Amendment. So, yes, we'll get into the Second Amendment. I'm getting there. We've got just a few more articles here that design the government, and then we will jump into the amendments. The Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. So this is an important piece of the Constitution that's been in the media the last few days. This piece right here. No persons except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of president. Neither shall any person be eligible to that office who shall not have attained the age of 35 years and been 14 year a resident within the United States. Now, this set was replaced by the 25th Amendment, and I'm not going to take the time to read through it because it just doesn't work anymore. We don't use this. But this happens to be what happens if our president passes away, who's next, and then the vice president, and then who comes after him. We've had, I believe, 9 presidents who have passed away or been assassinated. And so we passed the 25th Amendment in order to kind of take care of this situation because things just got so messy. So I will explain more once we get to the 25th Amendment. So this piece of Article 2 does not apply. Oh, thank you. Thank you. Yes, very random capitalization. I can't quite understand. What everything, it's very different. All right, so let's go on down here. The president shall, at stated times, receive for his services a compensation, which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive without that period any other emolument from the United States or any of them. So we have our next emoluments clause, and this is with specifying when it comes to the president. So I know that's been discussed quite a bit as well. So if you've ever wondered where that came from, it comes from this paragraph in Article 2. Before he enters on the execution of his office, he shall take the following oath or affirmation. Quote, I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States, end quote. All right, so there we've got that piece of Article 2. We've got just a couple sections left here. Section 2, the President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia, okay, of the several states. Again, this term militia that I think is misunderstood quite a bit. When called into actual service of the United States, he may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices, and he shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. So no parties for impeachment. He shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate, and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may, by law, vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. The President shall have the power to fill up vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. Section 3, he shall from time to time give the Congress information of the state of the Union, and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses or either of them, and in case of disagreement between them, with respect to the time of adjournment, he may adjourn them to seek to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. So that's the role again of the president here. The president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. So shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. So that is how you remove the president from office. All right, Article 3. And we've had a lot of talk about Article 3 because it sets out our courts and it gives jurisdiction to our courts. Some people have been asking, we've got a pretty high level criminal case going on, and can the Supreme Court get involved in that criminal case? So let's go through the jurisdictional limitations here. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress. So we've got congressional check here of our Article 3. may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior, which means lifetime appointments, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. The judicial power shall extend to all cases in law and equity arising under the Constitution. So we need a Constitution question. The laws of the United States, so federal laws, and treaties made of which shall be made under their authority, to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party. This piece of it as well has been replaced with some of the language of the 11th Amendment. To controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens or subjects. So, what happened here, we had the U.S. Supreme Court ruling on a case called Chisholm versus Georgia. And in that case, Mr. Chisholm was trying to collect some money that a particular man had given to Georgia during the war. He's like, hey, we gave you all this money. I'd like to get paid back. And he died. And so the executor of his will was like, hey, Georgia, you haven't paid this guy back all this money he gave you. And Georgia said, hey, under Article 3, Section 2, we don't have to. And we're not going to, and we're not going to go to court. So at the U.S. Supreme Court, they said, hey, we need to pull in Georgia to pay these debts back. You owe me. And the U.S. Supreme Court said, Georgia, come into court. You need to come and take care of this business. After that decision was decided, Congress said, we don't want to have to deal with that anymore. So they passed the 11th Amendment, the First Amendment after the Bill of Rights, that clarified who can sue whom when it comes to states. And so things are set out differently than the wording is how it was originally in Section 2. And it's because of this case, this Chisholm versus Georgia. Georgia had several cases in front of the U.S. Supreme Court involving debts, but that is the landmark case. So in all cases affecting ambassadors or other public ministers and consuls of those in which a state shall be party, the Supreme Court shall have original jurisdiction. So again, we're setting out the jurisdiction of the U.S. Supreme Court. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction. So they act as an appellate court. That's why they are the court of last resort, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. Now, I point out where Congress is being discussed in Article 3 because there's been a lot of discussion by the U.S. Supreme Court recently, a couple of justices in particular, that Congress doesn't have any business to do with the U.S. Supreme Court. And many constitutional law scholars say that is absolutely incorrect because under Article 3, Congress is put into here multiple times as a check against the U.S. Supreme Court. So kind of keep that in mind when you hear someone saying, well, Congress doesn't have anything to do with the U.S. Supreme Court. Look to Article 3, and you can see all of the places where Congress does have something to do with the U.S. Supreme Court. And it was meant to be that way as a check, if you look to the history. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be in such place or places as the Congress may by law have directed. Section 3. Treason, the only crime listed in the Constitution, just so you know. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act or on confession in open court. This is subject to interpretation. So we've got this huge broad language when it comes to how we go about defining treason. The Congress shall have the power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. So there we have treason set out in its most vaguest of terms. All right, so Article 4, we only have a couple of articles left. Again, all the articles are the Constitution. When we talk about the Bill of Rights, those were passed years and years later after it was ratified. So this is the actual Constitution. Section 1, full faith and credit shall be given to each state to the public acts, records, and judicial proceedings of every other state. And the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be approved and the effects thereof. Now, the 14th Amendment really solidified this after the Civil War. So this was kind of reassessed and reestablished after that. Section 2, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. Again, this is one of our most controversial sections here coming up. And is no longer applicable because we passed the 13th Amendment that did away with slavery. But until then, we had this section of the Constitution. Also, as a quick note for anyone who has questions about jury nullification, that's been coming up quite a bit. You know, what about jury nullification? How does that work? The single most utilized example of jury nullification in the United States was with regards to this section of the Constitution. So if you ever have questions about jury nullification, this is when it was used the most frequently in the beginning. So it dates all the way back. No person held in service or labor in one state, under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered upon a claim of the party to whom the service or labor may be due. Right, so this is the escape slave provision in the Constitution. So if slaves escape and get caught, they need to be taken back to their owners. Again, the most utilized piece of jury nullification was for this particular part of Article 4 of the U.S. Constitution. All right, so yes. You know, so many of the men that put this Constitution together were slave owners. I mean, it's just part of our history. It's part of the, it's written within the language of the Constitution in multiple parts. It's just that integral to the Constitution. Concept of sovereign citizen and what the Constitution says about it. The Constitution doesn't say anything about sovereign citizens. We have federal law that sets out how to reject your citizenship if you want. And we have a case called Trope v. Dulles, which was a U.S. Supreme Court case in which they said, the government can't take away your citizenship. You have to affirmatively go forward and the government can't take away your citizenship. You have to affirmatively go forward and reject your citizenship. So it's not something that can just be taken from you. So if you're rejecting your citizenship, you have to be in another country. You have to talk to a diplomat or some kind of a counselor. And so that's how you get rid of your citizenship. If you haven't done any of that, then you're a citizen if you're born in the country. That's just how citizenship works. And that's just federal statute. Rather than the Constitution. The Constitution sets out the supremacy clause in Article 6, and we'll go through that. But when it comes to citizenship, that stuff is all regulated through case law as well as through federal statutes. The Constitution just puts out the ability of Congress to pass laws regarding citizenship. And then, of course, we have a couple of cases that established it as well. Laws regarding citizenship. And then, of course, we have a couple of cases that established it as well. So that's how that works. That's why the sovereign citizenship stuff doesn't really, really work the way that a lot of the paperwork says it works. If you get adopted by a citizen, do you become a citizen? There's a lot of rules about that if you are not born in the country. So you have to have certain qualifications. And even if you are adopted, you still have to go through different citizenship requirements. It's not an automatic thing. So if you read through the rules, yeah, it is a bit boring, isn't it? It's a bit dry. It's going to kick up in a minute. In simple terms, what distinguish federal and state? It says it's both three branches of government. Right. Okay, so really the language that set out the legislative branch is what sets out what a state can and cannot do. So when we're getting into those final sections of Article 1, it says states can't do this, states can't do that. So rather than actually giving an affirmative authority to the states, which comes later in the 9th and 10th Amendments, in the articles, what they're saying is states are not allowed to do certain things, although when it comes to the Electoral College, they can. So our states look so much different then when they were drafting this. We only had 13, and some of them were super strong, others were not. Maryland was in a fight that brought France in because France was like, dude, Maryland, you need to, straighten up. So there was a lot going on. So when they wrote it, the intent was to kind of just be clear about what rights you have and what rights you don't have as states, because the Articles of Confederation were such a disaster. So it's not particularly clear exactly what rights states have and what rights the federal government has. It really is case by case. And we have these cases like the Chisholm versus Georgia case. We have the money cases. We've got a lot of different cases where the Supreme Court has gone in and had to kind of carve out what states' rights are in one way. And then depending on the Supreme Court, it kind of goes back and forth. So, it's a constant struggle from the very first day until today even. So it's quite a bit of a battle. Oh, thank you. Thank you. But that's the ultimate question. What power do the states have? What power does the federal government have? And it's something that's a fundamental difference of opinion on our U.S. Supreme Court. And, that's really the ultimate decision when it comes to contested cases, is how the U.S. Supreme Court decides. So, oh yeah, and we can't forget our indigenous populations and how pivotal the roles were with treaties, as well as the different parts of rights that were given as well. So oh, hello, Ulysses, welcome. We are going through the Constitution here. I'm finishing up with the articles, and then I will be digging right into the amendments, which of course is really where we get to spend some good time learning about how those amendments have been interpreted. So hopefully that explains it. But, we have that problem between our federal and our state government, and continuously. I mean, it's really an ongoing battle every day that we kind of have to deal with, that our U.S. Supreme Court really kind of digs around and messes around with. So all right, so we've got the refugee slave clause here, which is no longer in effect. And now we go into Section 3, which goes into new states. New states may be admitted by the Congress into the Union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state shall be formed by the junction of two or more states, or parts of the states, without the consent of the legislatures of the state, concerns as well as for the Congress. Now, as a brief side note here, all of those original 13 colonies were all set up as, British territories. So the original boundaries were kept, even though we declared independence from Britain. So the original colonies kind of got upset about that, because they're like, hey, the king's gone. We want to kind of redress or change our boundaries a little bit. Our lines are a little bit different, particularly Virginia. And so they put in here, wait, you can't just redraft everything just because, the king's gone. We have to kind of keep with what we have. And then when we add new states in, now we're going to talk about, boundaries and so on. So this was a huge fight that involved there were quite a bit of ungentlemanly behavior involved, which could be because of the consumption of wine, in my personal opinion, but whatever. But yeah, they were pretty upset about that. Rhode Island and Virginia were just completely nemesis when it was involved in the boundaries. Federal government applies to everyone, the states only for a particular area. Yes. So our federal government is our umbrella, and that's our big term, our big laws across everybody. And then they set out minimum guidelines. Now, each state can be more restrictive, but can't be less restrictive. So our states then will go in and kind of move the laws around to fit their particular citizens and what they need to do in their areas. So federal law governs these big, broad, minimal requirements for laws, and the different pieces set out in Article 1 for congressional duties, like the post offices and so on. But the states have everything else. So they're in charge of everything else. No, I'm not saying anybody was an alcoholic. I'm referring to the original the original leaders of the colonies at the time of the drafting of the Constitution. They drank a lot during the conventions, is what I'm saying. Yes, and they really did. If anyone looks at Benjamin Franklin's wine log during that period of time, there can be no debate about that. They had a lot to consume. Can you tell us that if born here, you are a citizen? Yes. Yes. And, that's not just because of the Constitution. There was a case. Let me just pull up the citation here. I want to make sure. I always kind of mess up the name of this case, and so that's why I want to make sure I say the name correctly. Okay, it's Wong Kim Ark is the U.S. Supreme Court case that made that decision. So it was because of his case that we have, if you are born in the country, you are a citizen. Let me write down his name. It's U.S. versus Wong Kim Ark. And he was born in the United States. His parents were Chinese citizens. He was denied citizenship until the U.S. Supreme Court came in and said, hey, if you're born in the U.S., you're a citizen. So this is the case. This is the law that made citizenship, if you're born in the country, part of it. So, of course, the parameters were set out in the Constitution, but the actual law itself is from that case. What year was that case? Let me see here. I have done a post on it, so you can type in the name into TikTok and you'll see it. It was 1898. So it was post-Civil War because they used the 14th Amendment in order to establish that citizenship. And this was because we had, of course, at that time, the Chinese Exclusion Act, which denied any citizenship to any Chinese immigrants. And of course, his parents were in the country when they had him. And so they held in this situation under the 14th Amendment, he was now an automatic U.S. citizen because he was born here. Yep. Very famous case, controversial at the time and still today. But that's the historical piece. So this larger idea of citizenship falls under the 14th Amendment, but it was that Supreme Court case that really established it. Okay, the Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be construed as to prejudice any claims of the United States or any particular state. The United States shall guarantee to every state in the Union a republican form of government, and shall protect each of them against invasion and on application of the legislature or the executive when the legislature cannot be convened against domestic violence. Now, Article 5, again, we are almost done. This is Article 6 and Article 7. So, and then we will be jumping right into those amendments and going through that. Well, Toma, I think a lot of people, that's a good question, and that's been used a lot, kind of a buzzword that's been going around. And, since the beginning, the way of looking at the law is it can be a shield or it can be a sword. And if you use it as a sword, a lot of people view that as weaponizing it. But if you use it as a shield, that's what protects you against people weaponizing it. So it plays both roles, depending on how you look at it. And that's, one of those legal philosophies that's really at the basis of our legal ideologies when we go forward on it. So, but it absolutely can be used as a sword, absolutely can be used. But then on the flip side of that, it can be used also as a defense to protect you from it as well. A Republican form of government, well, that gets controversial because anytime I say we're a democracy, people get very upset about that. But we technically, it's a constitutional representative democracy. If you would call this a democracy, James Madison would probably just fall over and pass out. But technically, under the way that democracy is defined, if you go all the way back to the Greek and Italian ways that were discovered regarding government, technically the giant umbrella term is democracy. But a republic means people are involved, so the people get a say. So rather than there being a monarch or a religious leader, those kinds of things, we have a democracy. So those Greek origins of that term just means a bunch of people, and a republic means the people have a say. A representative republic means the people pick representatives to have a say for what's going on. So that's really the political background and reason for those kinds of terms. But what James Madison's talking about here is that we have people having a say within their government. So we're not a monarchy. We are a group of people having a say in what's going on. Imperialism helped America understand the importance of democracy. Oh, I think so. Absolutely. And yes, and there's a direct democracy has its problems too, for sure. I think all kinds of governments have problems, but I think a lot of people get triggered when we use that term democracy. And, I understand, but from a political science perspective, technically these are kind of subcategories of democracy in the broadest sense as defined by, the Greeks and how this was originally decided in Rome and in Athens. So that term comes from there. And then we've kind of put different subcategories into it. Right. Pure democracy would be very difficult for something this size. I think it could happen in some places, but it really is size determinative to be able to have every single person come in, and the technical, practical aspects of that would be difficult. Yes, 80s gal, that's exactly right. What everybody says. And that's why people get upset about it. And I understand. I'm not saying we are not a constitutional republic. I'm not saying that. I'm just saying that technically, legally, and politically, the way that government was designed, that the republic form of government came under the umbrella of democracy, which was started way back in Athens. Is national the same as federal? They're used interchangeably. Yes, they are. It's weird because this term federalism means this kind of weighing of powers between the federal government and the state government, even though it's got the word federal in it. But federal government or the United States, all of that is covering the federal level versus the state level. But federalism means that we've got two kinds of government in the U.S. We have two levels. We have the federal level, which is one road, and we have the states level, which is another road. And they can kind of, move around, but they're separate roads. They don't cross each other. Only if the state is doing something that is beyond what the federal government allows for. That's the only time there really comes a conflict. But they've got their own role. They've got their own courts. They've got their own set of government, which is in, that umbrella for everyone. And the states have their own set of rules and their own government. They can be more restrictive than the federal government, but not less. Direct democracy is majority rule. Direct democracy just means every single person gets a vote. There's not a representation. It would be essentially, like having to call a town hall meeting and everyone being required to be there in order to get anything done. So probably nothing would get done if you've got a huge amount of people involved. Yes. Cooperative federalism. Okay. I see what you're talking about. I see where you're coming from. Yeah. Yep. The Republican form of government is separate from a party. Correct. And, originally we had the Federalists and we had the Anti-Federalists, and we had the Whigs, and we had the one party that was called the Democratic Republicans. That was one party because it was a democratic republic. So that was one party. And then eventually those split into two different areas that meant different things over time. So, Thomas Jefferson would have been the big Democrat leader. And then, of course, later on, we've got Lincoln, who was a huge Republican leader. And so those kinds of styles of the parties broke off much later. But the reason originally it was called a Democratic Republican Party is because that was the government that we have, as opposed to the Whig Party or the Federalist Party. So that's how those parties came about. Mm-hmm. Yes, and then the Whigs disappeared. Yep. Mm-hmm. Yep. Yeah. Yeah. No, I think you're right. I think you're right. I think a lot of people, because of how our parties are in the U.S., assume that a Democrat means democracy and a Republican means republic, but that's not what it means. That's really not. If you look, and you just have to look at the history of it, which is really long and drawn out and dusty. So not many people would, and that's understandable. My background is in political science, so that's where the history comes from for me. But that's where, yeah, yep, mm-hmm. Um, Right, John Adams. He did. That was a huge case for him because he again was like, we've got to have the appropriate amount of due process involved, and so I guess I'm gonna have to do this, and he did. So, absolutely, absolutely. All right, so Republican form of government, and then here we've got Article 5. This is how we go forward with amendments. So I will go through this because I think this is important. A lot of people don't quite understand how we add amendments. So it's set out in Article 5. The Congress, whenever 2/3 or both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments. All right, so those are our two roads. The Congress, whenever 2/3 of both the houses deem it necessary, they can propose amendments. Or on the application of the legislatures of 2/3 of the states, they can call a convention for proposing amendments. So those are our two roads, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states. Which is really what the problem is that we have a really hard time getting 3/4 of the states, or by conventions in 3/4 thereof, as one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year of 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, which has to do with Congress, and that no state without its consent shall be deprived of its equal suffrage in the Senate. So we've got voting rights here. And then that takes us into Article 6. Article 6, all debts contracted and engagements entered into before the adoption of the Constitution shall be as valid against the United States under this Constitution and under the Confederation. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. So this is a supremacy clause. This is the clause that most of the people that are kind of going down the sovereign citizens argument road need to remember. We have the supreme clause, which means it's the supreme law of the land. But this is saying, okay, the Constitution is the supreme law of the land, but within the Constitution, it says, the U.S. Supreme Court gets to decide certain things, and Congress gets to make different kinds of laws. And so, you can't just look to the four corners of the document because the document gives the power to make laws to all other kinds of places. So that seems to be forgotten sometimes when we go through that discussion with some people that are going down the sovereign citizens argument road. And the judges in every state shall be bound thereby. anything in the Constitution or laws of any state to the contrary notwithstanding. The senators, representatives before mentioned, members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. This was an essential debating point, and if you go back and you look at the discussions that people had when we put this together, put the Constitution together, this religious test issue was something that was a huge problem at the time. And so Madison put it in and said, hey, there's no religious test. We're not going to have that. And now Article 7 goes into the ratification process of this Constitution. So ratification of the Convention of the 9 states shall be sufficient for the establishment of the Constitution between the states, so ratifying the same. Done in convention by the unanimous consent of the states present the 17th day of September in the year of our Lord 1787, and of the independence of the United States of America, the 12th in witness, whereof we have hereunto subscribed our names. And then we have all of the people who were set out here in all of the different states. So that's the Constitution, okay? So a lot of people are like, well, first, freedom of speech, that's the Constitution. No. The articles that created the Constitution, that's the Constitution. Next up, though, we will get into the amendments. And, of course, we will go through the Bill of Rights and talk about that. So this is really, probably the most famous part, of course, of the Constitution. But those articles are what created that government. The U.S. is a Virgo. It could be. Can you tap and scratch? Yes, I can on here. I do not. This is for note taking. I do not make notes in my actual constitutions, but this one I print out for teaching purposes only. Just to kind of help things a little bit better. The Scorpio could be as well. What does wing mean, left or right, for governments and ideologies? Right wing or left wing, I think, again, that goes to those, the liberal versus conservative ideologies, I think is how that goes. I'm assuming it has something to do with the physical location in Congress is how it originally started, is what I would assume. But I don't have a fact check on that, so I wouldn't bet my life on it, but it seems that way. Yes, well regulated, and we'll get into that. They threw out 3/4 of the DC indictment. No, not to my knowledge. I just printed the docket just a few minutes before coming on live here. For anyone who was having questions. So I printed this out just an hour ago. Again, I'm a bit off topic here, but nope, we don't have any of that. We have a motion for an extension of time that was denied today because we've got a response for an extension of time and a motion for an extension of time. So that's the last thing that's been on file, and that was as of an hour ago. So you just heard it. Well, let me take just one moment. I'm all about the fact checking here. Yeah, no, I don't see anything. I don't see anything like that. And I'm looking directly at the docket. So nothing's been filed on that at this point. It might happen, who knows, but it's certainly not filed in court. If it's not filed in court, to me, it hasn't happened yet. So, yep. I've got this is the docket right here. This is the current status. So as of today, everything is the same as it was, just to fact check in the moment. So I did talk about the protective order earlier. I can certainly go into it again if people are interested in that. I can certainly go through that. Is that, are people still wondering about that? The Gemini, It's a Gemini. That's a good point, actually, to be a Gemini, because we do have the federal government and the state government, so we kind of are two bits of it. Yes. Okay. Would that be okay? Would it be okay if we go through that protective order for a little bit, and then I can come back then into the amendments? Okay. Let me grab the, okay, sure. Oh, sure. Let me grab the protective order. We can go through that. Sure. Absolutely. I would be happy to get some water. I will. Oh. Yep, I would be happy to go through that and explain that. All right. We'll just put I think we'll remember where we left off here. Put that to the side. All right, sure. Let's talk about it. Let's talk about the protective order. For those who are asking what happened, this was filed just yesterday. So let me just bring everybody up to speed here, I guess. You can go online and you will look up U.S. versus Trump, and you can find the entire docket. So down this side will be the number for the docket, and then, or the number of the document, the date that it was filed, and then what it is. What I did here was I just printed out the docket when it came to the protective order that came out. No illegal advice whatsoever or propaganda. Nope, this is just court documentation. So certainly not any legal advice. For the Constitution, it says Article 4, the U.S. Constitution, help with state and federal governments. I'll have to take a look at that. All right. Yeah, let me go ahead and just go through this. I have so many people have requested it, and I'm absolutely happy to go through it with people who are interested. So yes, what can happen on Monday? So yeah, let's talk about it. It doesn't take very long to go through it. All right. So with the docket, we've got number 10, document 10 set out here. There was a motion for a protective order that was set out by the government. Everything in green is the government, pink is the court, and then orange is the defendant. So I don't have anything here yet for the defendant, but it seems like there has been something filed. Protective order, and then there were attachments as well. And then we've got a minute order as to Donald J. Trump, as required by Rule 5F of the United States, order to produce all exculpatory evidence, and that's under the Brady Rule. And then we have an oral motion for a speedy trial by the United States. So this oral motion is what the defense is replying to later. This is a more updated version of what's happened today on the docket. So if we look today, we will see there was a motion for an extension of time, and this was filed by Donald Trump here, and the government made a motion for a speedy trial. They're asking for more time. So the order is saying here, it's ordered that by 5 p.m. on August 7th, the defendant shall file a response to the government's 10 motion for a protective order, stating defendant's position on the motion. If the defendant disagrees with any portion of the government's proposed protective order, his response shall include a revised version of that protective order with any modification in red line. So there is a chance to come in and say if there's any problems with it, then go forward. Motion as to Donald J. Trump granting 9 motion for leave to appear, pro hoc vice, that's something else regarding the media. Response by the U.S. as to Donald Trump's regarding the motion 11 for an extension of time. So this is what has happened today. We've got the minute order as to Donald J. Trump. So the defendant 11 motion for extension time is denied. All right. So I'm kind of speaking fast here, but let me walk you through it again. We've got an oral motion by the government for a speedy trial. Now we've got a response to that by Mr. Trump saying, hey, we need an extension. We're not pushing speedy here. And then the court is denying that motion for an extension. All right. So that's what's going on in the docket for today. And with that came this protective order that they're saying the defendant can respond to. So let's go through that protective order that has been set out by the government and the court. And I will explain that to you here. So, no need to be rude. Yeah, I think, I think it's good to know what's going on. So, and enough people were requesting, so I'm happy to explain it. Right. Oh, sure. Okay, so let's go through this. We've got, this was what was filed yesterday. So this is the government's motion for a protective order. Now, what's going on here is the government is saying, hey, we have all of this discovery information and we want to give it to the defendant as soon as possible. And this is important so that the defendant can make his defense. So let me read through this rather than just summarizing. I will go ahead and just read what the government's written because they've done it, they've written it out themselves. The government stands ready immediately upon the court's entry of a protective order, in this case, to produce a substantial amount of discovery to the defendant. Discovery that defense counsel stated at the initial appearance yesterday that he needed in order to abide by the court's order to propose a trial date and estimate the length of the defense case. To allow the government to begin producing that discovery, much of which includes sensitive and confidential information, the government respectfully moves the court for entry of the attached proposed protective order governing the disclosure of discovery by the parties in the above captioned case. The court can and should enter it immediately to allow the government to produce discovery because the defendant can seek at any time to modify the order if he objects to it. So that's what the government is asking for at this time for the protective order. Now, I'm just looking over here at the docket just to make sure that I have everything set. Yep. Okay, so let's go into the reasons why the government has to come in and explain why they need the protective order. So let's look at that. On August 1st of 2023, the federal grand jury in the District of Columbia returned an indictment charging the defendant with violations of 18 U.S. Code 371, 1512, which is that conspiracy to obstruct the official proceeding, 1512C2, obstruction or attempt, and then 241. On August 2nd, the government sent a proposed protective order to counsel for the defendant. Defense counsel substantively responded on August 4th, which was today, or yesterday, with a different proposed protective order that did not, in the government's estimation, protect numerous categories of sensitive materials, including grand jury materials and sealed search warrant affidavits. The same, in an attempt to reach a compromise, the government drafted a new proposed protective order, modeled on the one entered by Judge Carl A. Nichols in a recent criminal case, and provided it to defense counsel, noting that the government intended to file a proposed protective order today. In response, defense counsel asked the government to note in this motion that they did not have adequate time to confer. And now here is the argument that the government is making to support that. So, again, I'm just checking this docket. People are saying something has changed, but I don't see it. I mean, I just absolutely don't see it. Here, I'm looking at the docket right here. So, all right, so the government seeks to provide the defendant with discovery as soon as possible, including certain discovery to which the defendant is not entitled at this stage of the proceedings. The attached order would allow the government to do so, while also protecting a large amount of sensitive and confidential material contained within the first production of the government has prepared and will send as soon as the court issues an order. Such materials include, but are not limited to, materials containing personally identified information, as identified in Federal Rule of Criminal Procedure 49.1, Rule 6 materials including subpoena returns, witness testimony, and related exhibits presented to the grand jury, materials obtained through sealed search warrants and 2703D orders. Sealed orders obtained by the government's filter team related to this case, recording transcripts, interview reports, and related exhibits of witness interviews and sensitive materials obtained from other government entities. The court may, for good cause, enter a protective order governing or restricting discovery for inspection. And this is under Federal Rule of Criminal Procedure 16D1. And then we also have a federal case that's being cited. A trial court can and should, where appropriate, place a defendant and his counsel under enforceable orders against unwarranted disclosure of the materials which they may be entitled to inspect. And then the Alderman case, which is a U.S. Supreme Court case. Courts regularly do so to expedite the flow of discovery in cases involving a large amount of sensitive information. And this is another D.C. federal court case here. When seeking a protective order, the government must establish good cause. And here, good cause exists because the issuance of the government's proposed order would expedite the flow of discovery in this case. Give the defendant prompt access to a large portion of the discovery he ultimately will receive and protect the highly sensitive categories of material described above. The government's proposed order is consistent with other such orders commonly used in this district and is not overly restrictive. It allows the defendant prompt and effective use of discovery materials in connection with his defense, including by showing discovery materials to witnesses who also agree to abide by the order's terms. All the proposed order seeks to prevent is improper dissemination or use of discovery materials, including to the public. Such a restriction is particularly important in this case because the defendant has previously issued public statements on social media regarding witnesses, judges, attorneys, and other associated with legal matters pending against him. And in recent days regarding this case, the defendant has issued multiple posts, either specifically or implication, including the following, which the defendant posted just hours ago. And this is the screenshot there. If you go after me, I'm coming after you. If the defendant were to begin issuing public posts using details or, for example, grand jury transcripts obtained in discovery here, it would have a harmful, chilling effect on a witness or adversely affect the fair administration of justice in this case. And we're citing case law there. So the outcome of a criminal trial is to be decided by impartial jurors who know as little as possible of the case based on material admitted into evidence before them in a court proceeding. Extrajudicial comments on or discussion of evidence which might never be admitted at trial obviously threaten to undermine this basic tenet. Finally, and importantly, the government's proposed protective order protects that either party can seek to modify the order at any time, meaning that the defendant is in a better position if he receives discovery under the proposed order conditions rather than receiving no discovery while the motion is pending. So they're trying to give all of this information to the other side. If the court issues the government's proposed protective order forthwith, without awaiting a responsive brief, the defendant will be free to review discovery that the government will promptly produce and can seek any modifications of the order that he determines appropriate based on that review. And once in possession of the government's detailed, organized discovery inventory, the defendant will be in a better position to assess and justify whether to seek modification to the protective order at all. So this is the government's motion. Now, we have to look at it within the confines of what's been written to the docket here. All right, so we have the, let me just go through here. Here's the motion for a protective order. Let me just close. I just printed this just before I popped on the live here. So we have a motion for a protective order here, and then we have from the court a minute order. So this is where they're saying, as required by Rule 5F, all that exculpatory evidence needs to go to the defendant. Not doing so in a timely manner may result in sanctions, including exclusion of evidence, adverse jury instructions, dismissal of charges, and so on. An oral motion for a speedy trial was given by the U.S. as to Donald J. Trump. So again, this is another oral motion by the U.S. Now we've got a minute entry for proceedings held before the magistrate. Counts 1, 2, 3, 4, held on the 3rd of August. Plea of not guilty entered as to all counts. The court advised the government of its due process obligations under Rule 5.4. Status conference is set for 8/23. And that's again to review this exculpatory evidence requirements in courtroom B in person before the judge. Bond of status, personal recognizance, which is normal. Now, a minute order. As to Donald Trump here, a status conference will be held in this matter on August 28th at 10 a.m. before the judge. The court waives the requirement for the defendant to appear at the conference. It is hereby ordered that the defendant shall file any motion for excluding the time until the next status conference from the Speedy Trial Act clock by August 8th. Again, that just means if he wants to have certain things not count towards the speedy trial numbers, that's fine. He can do that. And the government shall, let me see. And the government shall file any opposition to that motion by August 13th. It's further ordered that by August 10th, the government shall file a brief proposing a trial date and providing an estimate of the time required to set forth the prosecution's case in chief during the trial. And that by August 17th, the defendant shall file a response brief, likewise proposing a trial date and estimating to the extent possible the time required to be set forth for the defense of trial. So now we go into what's been filed today. So we've got a motion for an extension of time and a response reply about the motion for protective order by Donald Trump. So now let me see here, when I'm pulling this up, I hope you're all following me. My mind is so far into everything. I'm just going through these documents here right as we're talking. So let's see, I've got their motion then, and then let's pull up the proposed order. Now, I've got the government's proposed order. Defendant has moved to extend the briefing schedule for the government's motion for a protective order. Well, that's interesting. Okay. I'm printing it right now. Do you want me to share that with everyone? Would you like me to bring that order out that I've just printed off of the docket? I can do that. Yes. Okay, let me go grab that out of my printer. Let me just take a minute here to make sure that I've got my own docket here clean. So we've got record number 11. This is the document here. A response to the USA, by the USA here. So this is the government's response. We have a minute order here, which is the government, an order on the motion for leave to appear pro hoc vice, a minute order as to Donald Trump, 5 p.m. by August 7th. Defendant shall file a response to the government's motion. So let me go pull those out of my printer. Do you want the government's response too? I think I did print that. I'll go ahead and grab that and then just show it to you. Now, I haven't read it, but I can bring that out. Sure, okay. Let me go grab that. I'll be right back. Okay, so yeah, there's no there's no time, I guess, to take off. All right, so what I had gone through, and for anyone who was here earlier today, I did go through the government's motion, and they had their proposed order here. So this is a protective order proposed by the government. Now, what I'm walking you through here is that what has been filed just today has been this motion for an extension of time. So I just printed that out. Let me then take you through this. So this was filed by Mr. Trump earlier today. There's really no rest for these kinds of cases. So I haven't read through this. Let me just peek and make sure that we're okay. Oh, we've got some redactions. That's interesting. Okay. We have Exhibit B. Pending counts. Oh my goodness. Whoa. Okay, this looks like, oh my goodness. That's the Florida stuff. That's interesting. Why'd they print the Florida docket out? I'm sorry, I'm just glancing at this real quick before I go through it with everyone here, and then they have their own proposed order. All right, so let me just take a drink of water here, and then we'll go through this motion. It's very interesting. Yeah, that is interesting. It was just filed. It looks like it was just filed within the last, let's see, I sat down at 7, so it was within the last hour and a half it was just filed. All right, so just so that everyone's on the same page here, the government filed a motion for a protective order. The proposed order is here. This sets out that defense counsel needs to make sure that no sensitive material is given to the defendant. He's not even allowed to take notes. Defense counsel can be held accountable for that, just to protect the safety of everyone, and only for the discovery that the government wants to give to him. Okay, so that's what's in this proposed order. So now we have a response that was just filed. So this is still hot off of my printer. All right. Motion to revise the briefing schedule and set oral argument regarding the government's motion for a protective order. All right, so it looks like they want to argue that out. All right, let's see. On approximately 6 p.m. on Friday evening, government emailed defense counsel its proposed protective order, which is document 10-1. Government entertained no discussion regarding the contents or scope of the proposed order, but instead demanded an immediate take it or leave it response. That's normal. Hours later, the government filed its motion. True, we've already gone through that. Requesting the court adopt the proposed order without awaiting defendant's responsive briefing, contrary to LCR 47, a bedrock due process principle, okay. According to this case here, which is another federal court case. This is my first time I'm seeing this, so I'm just taking a moment here to read through it. We're all reading through this together. So, ex parte proceedings, particularly in criminal cases, are contrary to the most basic concepts of American justice, should not be permitted except possibly in most extraordinary cases involving national security. Now, that's not quite right. I mean, I'm sure that's what that case says, but, ex parte situations happen all the time when we have safety concerns. So, all right, this morning the court entered, now this was just filed here just 2 hours ago. This morning, the court entered a minute order directing the defendant to respond by August 7th at 5 p.m. To ensure counsel had adequate time to prepare a fulsome response, defendant respectfully requests the court briefly extend this schedule by 3 days to permit defendant's response by August 10th. Okay, so he's asking for more time to review the protective order. This is substantially less time than provided for by this rule, which generally allows for 14 days to respond to motions, and will enable defendant to fully assess the proposed order and advise the court of applicable law. Okay. Let's see. I'm not sure why he needed a 24-page response. This should be interesting. I'm My interest is piqued here. My interest is peaked. Yes. No, this is an exact, and this must have just come down. All right. Additionally, a brief extension would provide time for the parties to meaningfully confer and potentially resolve this dispute without court intervention. So this is saying that he wants to talk to the government so they can come up with an understanding about the confidentiality of the discovery. Without doubt, discovery in this case will be extensive and likely present numerous complex issues. For that reason, it's essential to structure the parties' discussion in a methodical and ideally cooperative manner. Okay. Friday evening ultimatums given by the government before even calling defense counsel are wholly unproductive and undermine the potential for party-driven resolutions. Okay. Requiring a Monday response to a Friday evening motion likewise forecloses the possibility of agreement and would encourage such improper tactics by the government in the future. Ooh, that's bold. That's interesting. And that bumps us down. Indeed, the government's lack of conferral represents a concerning pattern. Just 3 weeks ago, in United States v. Donald Trump, the government made a similar demand for a Friday night response to a proposed protective order, followed by a near immediate motion for relief. The court admonished this recalcitrant approach and denied the government's motion without prejudice for lack of meaningful conferral. What? That the government would use the same tactics so soon after is plainly improper. So he's referring to his own case in Florida and how they asked for, they did a Friday night filing in Florida and the court admonished the approach, but denied it without prejudice. If you deny without prejudice, that's not a bad thing. It just means you need to change something. Well, that's interesting that he's pulling in his own. Yes, sorry about that. I'm completely drawn into this. Yeah, he's using himself as an example. He's citing his own case in Florida, which is absolutely fine to do. That's absolutely fine. So, okay, better, good. All right, defendant is prepared to confer in good faith regarding an appropriate protective order and the hopes that the government will accept his invitation to do so. In the meantime, an additional 3 days to brief this important issue is reasonable, consistent with the local rules, and serves the interests of justice. No party would be prejudiced by the requested relief, as this case is at its very early stages, and no matters are currently pending that require the immediate resolution of the motion. Now, if I was arguing this on the other side, I would say, we want to give all of the evidence to the defendant as quickly as possible, but we need some guarantee that it's going to be safe. That's what I would assume the government would argue. Finally, should the parties be unable to agree on an appropriate protective order, defendant believes a hearing would be beneficial to the court's determination of the motion, which involves significant legal, factual, and procedural issues that can be most efficiently presented and resolved in an oral setting. That's interesting. So they're saying, we should talk about it. As such, defendant respectfully requests the court set a hearing on the motion for the first available date following the conclusion of briefing. And we bump down here. As explained above, as a general matter, we think that it's important to confer prior to the filing of any motion. However, given the circumstances presented here where the defendant has been ordered on a weekend to respond by Monday afternoon, we determined it necessary to submit our proposed briefing schedule as soon as possible to obtain clarity regarding defendant's obligations. Consequently, we have not conferred with the government regarding this application. That's interesting. So they're frustrated that this is happening over the weekend. All right. Okay, so he doesn't like that they're having to get something on Friday from the government and having to respond by Monday. Respectfully submitted here. So that is their motion, but we're only on page 3 of 24. So let's take a look at what the exhibits are that defense counsel has put in. This should be interesting. So we've got Exhibit A in support of their motion. Let's look and see regarding the proposed protective order. Thanks for the email, but suggesting a meet and confer at 6 p.m. on Friday is not realistic. We will suggest to the magistrate judge that we will need time we will need to brief these issues and request oral argument as well. Please note in your papers that we did not have adequate time to confer. Thanks and have a good weekend. All right, so that was done Friday at 6:39 p.m. Whoop, am I in frame? Sorry about that. This is an exhibit attached to the defendant's motion for more time to address the government's motion for protective order for discovery that they want to give to the defendant but has sensitive information in it. Yeah, it's a lot. It's a lot. And in fact, I had pulled the docket before I sat down to do my live. And so this all has come out since I started talking on my live at the beginning. Oh, goodness. Okay. Hopefully I'm in frame again. All right. August 4th at 6:06 p.m. Thanks, John. We reviewed this and are concerned that it would leave large amounts of material completely unprotected in a way not contemplated by standard orders in the District of Columbia. In order to try to reach agreement, we have drafted the attached, which is modeled on a protective order recently used in a criminal case before Judge Nichols. Please let us know whether we can represent that you consent to it. We are going to file this evening in the interest of getting you discovery as soon as possible. All right, so we're going backwards in time. This was 6:39, this was 6:06, and now we've got 2:45. Hi, Thomas. We took this order from similar orders used in the district. The case in Florida, of course, is a classified documents case, which is not what we have here. We would be happy to address this with the court by submitting separate proposed orders and letting the court decide, but not sure why we need to have a special, more restricted protocol here. Interesting. Okay. And then going back earlier, had more than enough time. Yeah, maybe. 2:39. Thanks, John. This is a very different from what we proposed, which was essentially what was agreed to in Florida. We're interested in reaching an agreement on this, but see, this is what happens when you have so many cases going at one time. You get kind of this kind of traffic jam on, what's going on with what. So I'm not overly surprised, but all right, let me pull this down. Is this in frame? Can I just get a heads up? Are we in frame here? Okay, before I move forward. Oh, thank you. Okay, good. Okay, do not believe it makes sense, at this point at least, to go through sensitive, non-sensitive designations. If you can, that's interesting. If you can agree to that, we'll work on a blend of the two documents and send back a proposal. So he's saying, in this case, we don't have the same sensitive document issue. Is that what he's saying? Very different from what we proposed, which is what we agreed to in Florida. Okay. And then going back even earlier at 1:09, all John asked me to send you the defense's proposed protective order. Please see attached. Here. John and Todd. And so this is now August 2nd. John and Todd. Oh, I think he's showing how the government did this in his Florida case and is frustrated by that. It does sound a little bit like that. Okay, John and Todd, please find a proposed protective order. You will notice that it largely tracks with the existing protective order in Florida. Please let us know if you have any comments. Ideally, we could get this on file Thursday if you are in agreement with it. Thanks, TW. Yeah, his calendars, I think that's what's happening here, is that we're having this kind of mashing up here of all of the cases, which, legally we have been talking about that for a while now, how these were going to all come together. All right, Exhibit B. So that was Exhibit A, which are the emails talking about this protective order and the timing. So here's the next one. We've got U.S. District Court, Southern District of Florida, criminal docket for this case. Here, represented by these people, pending counts. Wondering why he is putting this in. Why does he have this as an exhibit? So he's got all of these counts listed out in the complaints, but why is this an exhibit? Another one with the defendant. Again, he's just listing, this is all known information. So he's putting into the court record his Florida case, all of the counts, all of the defendants. All of this is now going into his DC case, which is why I'm not sure why he's doing that. Let me keep looking here. I'm going to keep on and put on my, oh my goodness. Yes, it really does. So let's take a look. I mean, why is he submitting this with he's okay, so let's think about this. He's requesting more time to respond to the government's protection order because the judge is saying you need to let us know Monday afternoon if you're okay with their proposed protective order. And he's saying we need more time and that the government did this in my Florida case. Is that why he's adding in papers of his Florida case? So the first exhibit A, goes through the emails regarding discussions of the protective order, and now B is just setting out his Florida case. I'm not sure what the intent is here. Like, what is this? This is just the docket. This is the docket for Florida. Yeah, and it's the weekend. Yeah, it's the weekend. Yeah, why is he filing his Florida docket as a reason to ask? I guess, I mean, you don't have to, is he trying to say he's so busy in Florida that he needs more time? Because all of this, I mean, I don't see the relevance of this. All he would need to do is, file what's going on at the moment. But why is he going all the way back into everything that's been filed? I mean, this is a great record for the rest of us to be able to go through and say, hey, which document, what date? This is great for us, but I'm not sure why he needs to file it as an exhibit here. But okay, I'll keep going here. We've got even the pattern jury instruction builder here. What are we doing here? Notice of attorney appearance. All of this is all part of the docket. I'm glancing just to make sure that there's no, redacted transcript deadline. All of this stuff is, this isn't something that you would put in a court document that you would file in another case. And all of this information is, it's public, but it's private to him. I'm not sure why this would be. All right. Sorry. I'm like, what? We've got another paperless order. Okay, here we go. Maybe he's trying to show the part where the judge admonished. So let me just look in and scan through this and see if he's included resetting deadlines. Let's see. All right, let's get to the last page here. Let's see. Notice of a hearing, minute order for proceeding. I don't see it. I don't see it. Response to standing order of discovery by the government. I mean, is he trying? Okay, speedy trial report, paperless order, arraignment, superseding indictment, motion for a hearing on potential conflicts of interest pursuant to. Oh, that's interesting. I don't think I've. So okay. Oh, there's a conflict of interest. I have no idea why he would file the docket of his Florida case in his motion to ask for more time to respond to the government's motion. I don't know why he would do that. I'm not sure. I thought that he was going to try to show where the judge admonished the government for saying, hey, don't file stuff on Friday, because that seemed to be his argument, but I didn't see that in the docket. Yeah, I have no idea what's going on with that. He has something on August 10th. Okay, let me take a look. Again, I just printed this out. So, all right, here we go. The arraignment on superseding indictment is set for August 10th at 10 a.m. For the U.S. magistrate judge. Okay, the arraignment. Oh, well, let's take a look at that. All right, so we've got the arraignment here. The superseding indictment, Fort Pierce Division. But she is asking for a response by August 7th. So let's go back and just make sure I've got those dates correctly. So, okay, the court entered directing the defendant to respond by August 7th. To ensure counsel's got adequate time, defendant respectfully requests that the court briefly extend the schedule by 3 days to permit defendant's response by August 10th. But now in Florida, he's supposed to go in for the superseding indictment arraignment on the 10th. Am I reading that right? So I don't know if he has to appear for that or not. I don't think so. So he's asking for a 3-day extension for a response. Substantially less time provided than this one. Yeah, I don't think he has to appear for it either. I think you're right. All right, so he's got his, 2 exhibits in here. I'm not sure what role they're going to play, but you can do what you want. That's no problem. Now here is his proposed order. The defendant's move to extend the briefing schedule for the government's motion for a protective order. Upon consideration, defendant's application is granted. Oh, all right. So defendant shall respond to the government's motion by August 10th. A hearing will be held on this day. So that's his proposed order. And we have the government's proposed order. But let's go back and see then how the judge responded, because she's already responded. Oh, before I do that. So after he filed this, again, we're going to just keep this as orderly as possible. Here's his motion. So let's see what the government says in their response. All right. So here's the government's response today again. So he's asking for more time, and the government is saying, here's their response to his asking for more time. The government wants to provide discovery to the defendant. By his motion, the defendant seeks to delay the process. The defendant's motion should be denied. 3 days ago, on August 2nd, the government proposed to defense counsel a protective order that largely tracked one entered in the defendant's other pending federal criminal case in the Southern District of Florida. See defense motion for an extension of time, which we just read. In emails not appended to the defendant's extension motion, the government followed up on the evening of August 3rd as early afternoon of August 4th. Thereafter, defense counsel finally responded by sending an entirely different protective order. Since the defendant's proposal was inadequate, the government proposed another alternative, this one modeled after a protective order entered in a case before Judge Carl J. Nichols, recently tried by one of the defendant's attorneys present at his arraignment. Oh, so it's even from a case one of his attorneys was involved in. So there's that. So that's interesting. Defense counsel declined to substantively confer on that proposal on a Friday evening. All right. After which the government moved separately for entry of the order. The court ordered the defendant to respond by Monday with a red line of government's proposal. See this order here. Rather than spend time complying with the court's order, the defendant drafted a filing as to why he did not have time to review and consider the 5-page proposed protective order. Ouch. Ouch. That's not very nice. Oh, that's not very nice. The defendant's extension motion proposes unnecessary delay to normal order. The defendant suggests that the delay will enable defendant to fully assess the proposed order and advise the court of applicable law. Nothing prevents defense counsel from doing just that on the schedule already ordered by the court. To the extent defense counsel wants to confer further, government counsel is available at any time, evenings, weekends, or holidays. Oh my goodness. Oh my goodness. And if the court enters the proposed protective order and the defendant later is dissatisfied, the defendant can seek to modify the order at any time. The government stands ready to press send on a discovery production. The defendant is standing in the way. Ouch, that's not very nice. Oh, the court should deny the motion. Oh my goodness. Oh my goodness. Ouch. Yeah. Rewind. Okay. Let's take a step back. Let's see what's going on here. Oh my goodness. Yeah, the government is salty. Okay, so let's just see here. Oh, what's happened? Oh my goodness. This is, oh my gosh. Okay, so we have the government's motion for a protective order, the government's proposed order here, which, I went through already today, going through, and it doesn't take very long to go through that. So then Mr. Trump responded saying, we want more time because it's a Friday, I guess. Set out the docket as an exhibit, set out some emails, and wants more time. So let's see what the judge has to say about all of this here. So the government filed a response, and here is the order by the judge. So we've got a minute order here. Defendant's 11th motion for an extension of time is hereby denied. All right, so there's that. So that happened. The defendant may continue to confer with the government regarding its proposed protective order before or after the August 7th, 2023, 5 p.m. deadline for his response. The court will determine whether to schedule a hearing to discuss the proposed protective order after reviewing defendant's response, which is typical. That's how you're supposed to do it. And if included, his revised proposed protective order with modifications in red line, signed by the judge. Okay, so he's been denied. So he has to respond by Monday to the government's proposed protective order. Okay, so, my goodness. Okay, so that's what that means. I guess it was, that's a lot that just happened in 2 hours on a Saturday evening. Oh my gosh. Boy, this judge she's not playing around. She's not messing around. She's setting it out. Yeah, hit send. It would make a great movie. Yes, he literally just needs a red pen to cross out and make a couple notes. It seems like it. Yeah, it seems like it. And the order that's proposed is pretty, it's pretty open and shut. With the clarifications, you can just say, "Hey, I like this. I don't like that," and we're kind of done with that. It seems like it. Like the government's saying, "I don't know why you need more time," because in the amount of time it took them to put together a 24-page motion, which is what they did here. Again, I think the government's got a good point. I'm not saying anybody did anything wrong, but this is a 24-page motion. So the time that it took to put this together and file it with the court, the government's saying, you could have just reviewed the proposed order. I think it's a good point. Ken Burns, yeah, they're like, we don't like the fact that you're pushing us to do this. And I think that's really going to be a heavy theme throughout all of this, is that the defendant's going to be pushed into places he doesn't want to be. And that's true for any defendant, not just this one, but you have to go to court when the judge tells you. You have to do what the judge tells you to do. You have to file when the judge tells you to file. You have to follow the rules. And that seems to be something that's really bothersome in this situation. So, but the judge wasn't having that with that. She wasn't. Oh my goodness. So, okay. So that's that. That's what's happened with the government. Oh my gosh. Yes. Someone who's never had to practice restraint has to suddenly behave after 80 years. I think we have a lot of situations where, the court's not messing around. When the court gives you an order, you have to follow that order. So if that government order that's been proposed goes forward, you have to be within the confines of that. You just have to do it. It can be very frustrating to sit there and have a judge kind of come after you for one reason or another. But no matter what happens, you still have to follow the rules. What is a protection order? The protection order is something that says, we've got evidence we want to give you, but it's got sensitive information in it. And so we want to make sure it doesn't get out to the public. So that's really what the whole point of it is. And with this government proposed order here, and this judge is just saying, look, we need to know what your thoughts are on the protective order by Monday. And then why the rush? I think, I think that's a good question, and one that the defendant brings up. And I think the rush is kind of set out in the government's motion here when the government put their motion in, and they're saying, look, just a couple of hours ago, this statement was put out on the social media, and we're worried about what else is going to come out, over the weekend, what else is going to be shared. And so we want to give you information, but we're not sure that it's going to be safe to do that. So I think part of it is the argument the defendant is making is, we can't do a speedy trial. We can't set the schedule too quick because I need to review everything. And I don't have everything. The government's not giving me everything. And the government's like, well, we want to give you everything, but we're not sure that it's safe. So I think that's kind of what the issues are that are, at play in this situation. Right. And I think a lot of information is important to be made public, but some of that sensitive information, like people and locations of witnesses and information, things like that, that could be incredibly detrimental if that information got out. So, it's an interesting situation here, but the judge just seems to not be having it at this moment. What website did I pull this from? This is all filed if you go into your search engine. And the reason I use such vague terms is because it depends on where you're at, what website's going to be available and pop up for you. But if you go to your search engine, you put U.S. versus Trump, Washington, D.C., or just D.C. court filings, and there will be several sites, and you can pick which one you want to go to in order to pull up the docket. And then within the docket, they will have all of these different PDF files of all of the motions and proposed orders and stuff. Sure. Oh, sure. It's in the secret court document drawer. Don't tell them. Oh, too late. Oh, no, Chris, no. It's too late. I've given too much away. No, I'm just kidding. This is all public, completely public information. I wouldn't share it if it wasn't public information. Yes, Pacer. Yep. Pacer is one of those resources you can use. I only use free resources just to make sure that everyone else can have access to it. I don't use my secret lawyer resources because not everyone has access to secret lawyer resources. So I don't really think it has anything to do with the election. I think it has to do with, asking for more time, and there's a lot going on. But when was this filed? It looks like the government's motion and proposed order was filed yesterday. And it looks like the response to that motion by Mr. Trump was filed today. So his response to the motion was filed today, and then the government's response to his response was filed today. And then the judge just issued this denial today as well, and just within the last couple of hours. So this just happened. This was just put on the docket. I was just on a live talking about the Constitution, and then I'm like, what just happened? So yeah, it was pretty fast here. And, he's got a lot going on. He's got a lot of things going on. So it makes sense that that would be something that he's interested in. But on the other hand, the government's like, look, we've got all this evidence. We want to give it to you, and you should have it. You need it for your defense. And that's how it should be. But we need to make sure that everything's done so that everyone's safe. So is that unusual how quick all of these were filed today? It is. Honestly, it is a little quick. I sat down just to double check, and I looked at the docket before I started doing my live, and printed out the most recent view of the docket. And then just, an hour and a half into my live, we've got all this stuff set out on a Saturday evening. Yeah, it's a lot. It's a lot, and it's quick. But again, they're trying to get this response to the protective order in. So they don't have Diet Coke and McDonald's and lockup. They really don't. They don't. Yeah, I think a lot of people want it over and done with. You're right. Absolutely right. Absolutely. Yeah, they did go quick. They did. Yes. A response to a response is a reply. Right. I kind of do a lot of different terminologies, whatever I think is the easiest way. This is what courtroom shows should be a civil order. Maybe. Yeah, this is just, it's real time here. What's going on? Can they remand him to jail for what? For what, Bella? You'd have to tell. There hasn't been any violation. I think once the protective order gets put into place, a violation of that, we're going to be looking at contempt of court if there's a violation. But so far, we don't have any violations here whatsoever. So I don't think there would be any reason. What does the protective order do? It protects the discovery information the government's trying to give to the defendant. And it just means that names, dates, places, sensitive information, they don't want him to have that information in a way that he would put that out into the public, put that on social media, because if he goes into the details of people's names and where they live and their phone numbers and puts that on a social media account, what's going to happen to those witnesses? What's going to happen to those people, or those specific details of what was discovered in a warrant? There's all kinds of little bits and pieces of information like that can cause huge harm. So that protective order makes it so that kind of information can't be made public. Now, he needs it and has a right to that information to put on his defense. He absolutely has a right, and it should be given to him. But what they're trying to do is protect their witnesses and to protect the evidence so that there's no harm done to the witnesses and the evidence while they're getting ready for trial. Yeah. Truth Social post about Pence. I don't know. I haven't seen that. I feel like I'm behind. I'm just like, I think I'm on top of everything, and then sit down and talk about the Constitution. All of a sudden, boom, we got another order that just came down. So it's a lot. Yes, it would. It would protect Mike Pence. Absolutely. Anybody named in the indictment, any information that they have, it would protect that so that those kinds of details wouldn't be made public. So if somebody had some ill intent, and I'm not saying the defendant would, I'm not saying he would have an ill intent whatsoever, but if that information somehow, even accidentally, or he didn't think there's any harm in sharing it with someone, made it out to the public and someone with bad intent got it, then someone or evidence could be in danger of being destroyed or tainted or messed with in a way. So, they want to just keep that protection in place. But I mean, they also want to make sure he has all the evidence that he needs to go forward with his defense, because that's his constitutional right, his absolute constitutional right to have that. Right. I mean, we've got evidence within the indictment of what happens when information is made public in certain ways, and we can see what can happen. So they want to kind of head it off before it becomes a big problem. I think Kanye has all of us messed up a little bit. Depression, way to spend a Saturday night. No, you're right. I wouldn't censor that. That's, I think, a true statement. I believe that. I believe that. He would say something on the stand that would put him in contempt. Could be. It's possible. I think many defendants that are at this level that are charged like this have a very difficult time being forced to do so many things that they don't want to do. I think it's very difficult for someone that is in a power position, anyone, pick whoever you want on the other side, and they're forced into court and forced to sit and stand and do what the judge tells them to do. I think that's very difficult for them to do. Are they going to put him on the stand? I doubt it. I think if there's no other way to prove an intent element that they need to prove as part of his defense, then he might need to testify. But freedom of speech, he has a right to speak about why would they censor? Freedom of speech doesn't protect harming other people. That's not how freedom of speech works. That's why people get charged with harassment or libel, defamation. Freedom of speech does not protect those kinds of things. So if he says something and it leads to harm of someone, or it leads to destruction of evidence in some way or some manner, that's not protected. So, right. Freedom of speech comes with great responsibility. That is an excellent term. Yes. I think I'm going to make a t-shirt that says that. It does come with great responsibility. They do. All presidents have an enemies list. Absolutely. And I wouldn't say that he would put information out necessarily with any ill intent, but if someone in the public has access to it, then their ill intent could go forward, and it could be, really detrimental. So those who called illegitimate should be indicted. Illegitimate, I'm not sure what you mean by that. Do you mean the election was illegitimate? No, I don't think so. I think this charge is about interrupting a government proceeding. So I don't think it's about any kind of illegitimate whatevers. It's about a proceeding that was interrupted. So anyone that was involved in interrupting a proceeding, could be charged with interrupting the proceeding. That's really what it's about. Yeah, I'm not sure. I'm not sure that that's really the best course. What would happen if the evidence names got leaked after the order? Well, that's why the protective order would be put into place, would be because if it was proven whoever leaked it would be violating that protective order. And they could be found in contempt of court and they could be looking at jail time. What do you think the SCOTUS will rule when it gets there? The SCOTUS doesn't have jurisdiction. There's no jurisdiction here. They can appeal, they're an appellate court for federal law, or constitutional questions, but there's got to be some kind of violation of the Constitution or a final decision that you can appeal before the Supreme Court gets involved in it. So that's just how jurisdiction works for the U.S. Supreme Court. Mm-hmm. Yeah. Well, it's possible to appeal it there, but again, you can only appeal once you have a final verdict. So we'd have to have a trial, we'd have to have a verdict, and there'd have to be some allegation that something was wrong with it and appeal it through the system. I don't have any information whatsoever that Jack Smith is compromised. I don't have any of that information whatsoever. Can you check your super secret software and look at Jack Smith's victory percentage? I could. I'm kind of trying to stay a little bit on the edge of not knowing that kind of information. I really haven't looked into that, but I think there's a lot of people going both ways on that. But yeah, again, and it is unethical for me to speak negatively for a licensed attorney in my profession, or to kind of cast my profession in a negative light. I can have my own views and opinions on that, but I certainly don't have any evidence that would support that he's corrupt whatsoever. I have no evidence of that whatsoever. Doesn't get the verdict he wants, he can appeal on some perceived wrong, jury's biased, etc. Well, you have to have, I think that's for all defendants, for any defendant. If you are found guilty, you can appeal, saying, ineffective counsel, or something was wrong with the jury, or the judge made a bad ruling on a motion and a piece of evidence got in that was too prejudicial. And that's just the nature of, if you lose your case, you can absolutely appeal based off of those kinds of questions. Trying to dig. Again, I don't know anything about Jack Smith. I don't know anything whatsoever about him. I respect the hard work that prosecutors do. I don't give them a lot of leeway, though, because they are prosecutors. So they have to really do their jobs, and they have to do their jobs correctly. I think that's very important. Very important. This will be appealed in any decision. I think if there's a finding of guilt, you could appeal on grounds, but we'd have to see about that. So, okay. All right. So I feel like I have kind of gone through this. For those of you who are interested, hopefully I've explained this well enough for everybody. We will see kind of what happens here, but I do have some wonderful, amazing people who've been on this live for hours with me because we've been talking about the Constitution. So I did want to go ahead and get back to finishing up the Constitution if I could. I find absolutely no offense if you are wanting to move on to someone much more interesting than I am. But I do definitely want to kind of tackle those amendments that I, as promised when we first started this live. So yes, you're welcome. You're very welcome. Yep, I'm going to go right into the amendments here in just a moment and walk us through those amendments for anyone who wants to stick around. Oh, you're welcome. Absolutely. Yes, you're welcome. I'm glad I could help people out here. I'm glad that could be of assistance, but as promised, let me grab my Constitution again, and I will take us through these amendments, which is kind of that part of the Constitution everybody is so much more is interested in, but hopefully I've been able to explain things well enough for everyone. So yes, off you go. Back to work then, and have a great shift. Thank you for anyone who's joined briefly. And again, I take no offense if you want to move on. But I will go ahead and jump back into what my life had been on before everything was before everything kind of got a little different. So yes. Yep. Let's dive right back in. Thank you everybody for your patience. For those of you that were interested in that update that just came in while I was going through the Constitution, thank you for staying with me here. I will go ahead and dive right back in, and we'll go through these amendments. Yes. Oh, absolutely. You are welcome. And again, I will put all of this up on my Two of You channel for anyone who wants to. This document I got from the Constitution Center in Philadelphia. So they do really, really good work. Very, very good work. All right, let me take you through the amendments. Again, thank you so much, all of you that were hanging out with me since the very beginning, and I will just move on in. So one thing that I think a lot of people don't realize is that we actually have a preamble to the Bill of Rights. You know, I think that might not be something that most people realize. So we do have a preamble like we did to the Constitution. So the preamble is just these few paragraphs here. It's just, again, the Bill of Rights was added to the Constitution after the articles that design the government were passed and ratified. So this came in years later. Madison drafted 12 proposed articles. 10 of them were agreed upon by the first Congress and passed, and those later became called amendments, and those are our Bill of Rights. So they did include a preamble to that here. And set out, again, the term articles are switched to amendments later. But the preambles here, I do have a post up on that. So if you're interested in that, that's great. But I do want to jump into the amendments and kind of get into what's going on here. So the very First Amendment has so many pieces to it, and a lot of people find that First Amendment to probably be the most famous of all of our amendments to the U.S. Constitution. And it states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably to assemble and to petition the government for redress of grievances. So we've got 5 separate rights set out. 2 with regards to religion, the Establishment Clause along with the Free Exercise Clause. We do have some limitations. One of the most obvious is that you can't marry more than one person. That was established in the Reynolds case by the U.S. Supreme Court, and they said, hey, great, we respect religion, but for purposes of our country and it functioning properly, you can't marry more than one person. Along with this, again, this Establishment Clause. There's been a lot of talk about that lately, about what that means, and the U.S. Supreme Court has a lot of cases on that. And then next, of course, we have freedom of speech. There are some regulations here for obscenity, defamation, inciting violence. Those kinds of things are fighting words not protected by freedom of speech. The press, we've got defamation issues here. Peacefully assemble, we've got time, place, and manner requirements in order to prevent a clear and present danger. And this will go hand in hand also with petitioning the government, which means we can sue the government if we've got problems with the government. That's what it's setting out there. Now, this First Amendment, all the elements have been applied to the states. We've got something called the incorporation doctrine, which means the U.S. Supreme Court, through the 14th Amendment, has to hold on a particular case in order for that piece of the amendment or the amendment to apply to the states when it comes to the Bill of Rights. That was established through a long set of cases where originally the Bill of Rights only applied to the federal government. So there are a few pieces of the Bill of Rights that still do not apply to the states because they've not been incorporated through the U.S. Supreme Court. Now, one of the biggest ones, of course, is the Second Amendment. The Second Amendment was not incorporated or applicable to the states until 2010. First, we have the D.C. v. Heller case, which was written by Justice Scalia regarding First or Second Amendment rights and individual rights for weapons, for guns. And then we had the McDonald case. And between those two cases, the Second Amendment became incorporated to the states again in 2010. Now it states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Two specific clauses within the Second Amendment. We've got the militia clause, which was set out within the articles earlier. So the militia is something very specific and has a specific meaning. And then, of course, the second part, which is keep and bear arms. And we've had a lot of case law that's come up to explain what keep and bear arms means. Before, again, 2010, it only applied to the federal government, did not apply to the states. We had a case in the 30s, U.S. v. Miller, which was the very first case that discussed this idea of an individual right when it came to keeping and bearing arms. And this had to do with the Valentine's Day Massacre and whether or not a person can own a sawed-off shotgun, if that was allowed or not. But that was in the 30s. So it took another whole bunch, multiple decades later, before the issue was really put in front of the U.S. Supreme Court in a way that they could address it to the states. So we've got a lot of different cases that have set out what those rights represent. So I have been slowly creating a live where I will be going through the cases for the Second Amendment. The most recent was the New York Rifle Association case v. Bruner, which just came out recently, and that had to do with the New York State statute on whether or not you had to have an appropriate reason to have a permit in order to carry something for self-defense. The Supreme Court struck down that particular language in the statute, which was expected and known. New York had even tried to change the statute before it got to the U.S. Supreme Court, but to no avail. So we do have that most recent case. I will be doing a live specifically on that case because it is so important. So as an attorney, how do you feel about sealing the defendant's discovery from the public eye? I think we have to be careful and we have to make sure that people are safe. I think our system is set up in a certain way. We have rules, we have regulations, but at the end of the day, we have people with family and with safety concerns. There is no U.S. Supreme Court case that has incorporated the Third Amendment to the states, so it only applies to the federal government. There is a side note on this. The Second Circuit has held when it comes to National Guard kinds of situations that they believe the Third Amendment should apply, but that case never made it to the U.S. Supreme Court, so it's not been incorporated to the states yet. So in the Second Circuit, yes, the Third Amendment could arguably apply, but to the rest of the states, the Third Amendment does not apply. No soldier shall in a time of peace be quartered in any house without the consent of the owner, nor in a time of war, but in a manner to be prescribed by law. This was a huge issue with the British soldiers. It was such a huge issue. It was actually written into the Declaration of Independence by Thomas Jefferson because the British soldiers would come into the colonists' home, take their food, take their property, take their spouses, whatever they wanted. And so this was a huge issue. That's why it became the Third Amendment. But again, does not apply to the states, has not been incorporated yet. Next is the Fourth Amendment. This is what we would call the beginnings of our privacy rights doctrine. Privacy right is nowhere specifically written in the Constitution. It's in what we call the penumbra or the water blots of the Constitution. It's implied, but not specifically written out. So the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, which means they can do searches and they can do seizures, but they need to be reasonable, shall not be violated, and no warrants shall issue but upon probable cause, supported by an oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This is the warrants clause of that Fourth Amendment and has also been fully incorporated to the states. And we say if there's been a search done without a warrant, we're going to go ahead and view that as per se unconstitutional. There are, of course, exceptions, a lot of exceptions to the warrants clause, such as plain view or incident to an arrest. Lots of exceptions to that warrant requirement. That takes us then to the Fifth Amendment. The Fifth Amendment has some pieces that only apply to the federal government. Again, this is a really difficult concept, I think, for a lot of people to kind of wrap their head around because it doesn't seem to really coincide with how we're taught. But no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. I'll pause right there. that right of a grand jury is not applicable to the states. I know. Unless your state constitution requires a grand jury, it is not required under the Fifth Amendment to the United States Constitution. It's just not been applied to the states yet. So if you're at a federal level, you're going to always have a grand jury. But if you're at the state level, you may have a written indictment, which is just done by the local prosecutor, finding of probable cause, and then sent in. That's why we get that phrase, you can indict a ham sandwich, because it's really up to that local prosecutor to fill out paperwork and file it with the court, because the right to a grand jury indictment is not guaranteed to the states. So, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Again, not incorporated to the states here yet, this particular piece. Nor shall a person be subject for the same offense to be twice put in jeopardy of life or limb. That has been incorporated. That's the double jeopardy clause. Nor shall be compelled in any criminal case to be a witness against himself. That's the self-incrimination clause. So when people say, I plead the fifth, they're referring to this specific clause. Nor be deprived of life, liberty, or property without due process of law. This is the federal due process clause, meaning due process of law here only applies to the federal government. Again, I know it's hard to wrap your mind around it. The 14th Amendment has a due process of law clause, and the 14th Amendment due process clause is what applies to the states. The 5th Amendment due process clause only applies to the federal government. Nor shall private property be taken for public use without just compensation. That's our just compensation clause. And that, again, it has been incorporated to the states. Oh, sure. I think this idea of what applies and what does not apply to the states is something that is lost, I think, a lot in our conversations. So, all right, the Sixth Amendment, we've got our criminal trial rights. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and districts wherein the crime shall have been committed. So we've got the jurisdiction where we need to prosecute, which district shall have been previously ascertained by law and to be informed of the nature and cause of the accusation, to be confronted with witnesses against him, that's the confrontation clause, to have compulsory process for obtaining witnesses in his favor. So we've got the subpoena process here, and to have the assistance of counsel for his defense. This was applied to the states in the 1960s through the Gideon versus Wainwright case. Before 1964, I believe, we did not have a right to counsel when it came to criminal cases. So that piece of it was incorporated through that case. Now we've got the Seventh Amendment. Now the Seventh Amendment does not apply to the states. It doesn't. Again, I know you're going to be frustrated and upset, but it's not been incorporated yet to the states. In suits at common law, where the value in controversy shall exceed $20, or whatever the limit is these days, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in a court of the United States than according to the rules of the common law. So we've got any of our civil cases. Have you ever noticed whether or not civil cases you have a right to a jury trial? You do not, because the Seventh Amendment does not apply to the states. If your state constitution puts a right in there saying you have a right to a jury trial for a civil case, then you have that right. But if your state constitution does not say that, you do not have a right to a jury trial for a civil case. That's what that Seventh Amendment says, and it's because it's not been incorporated yet to the states. My YouTube channel is the same as my TikTok name. Yep. So, Seventh Amendment doesn't apply to the states. Now we get into the Eighth Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Now, this terminology, cruel and unusual punishment, the definition has gone back and forth. There was a period of time when capital punishment was deemed cruel and unusual back in the 60s. And then it was deemed a few years later to be fine. So it's kind of flip-flop depending on what the U.S. Supreme Court has decided at the time. Now, this excessive bail and fines, this piece of it was not actually incorporated in the states until 2019 with a case that Justice Ginsburg wrote, where we ultimately did finally put this piece of the Eighth Amendment towards the states. That was in 2019. The Ninth Amendment, the Ninth and 10th Amendments are kind of our catch-all amendments, some of the most confusing of all of the amendments because they are so vague. Where does it say the 7th Amendment doesn't apply to the states? Right. All right, so let me pause for a minute. Let's talk about this. We have a doctrine called the Selective Incorporation Doctrine. This is based off of case law. It has to do with multiple cases that went to the U.S. Supreme Court after the Civil War. Now, once the Civil War was done and we passed the 14th Amendment, when cases went up to the U.S. Supreme Court, the argument was because of the Due Process and Equal Protection Clause of the 14th Amendment, all of the Bill of Rights should apply to the states. The U.S. Supreme Court initially said no, they only apply the way that we want them to apply. Eventually, we had cases that went up where they finally said, okay, we will incorporate your Bill of Right that you're arguing about through the 14th Amendment because the Civil War, we passed that amendment. So now we have to have a case in controversy regarding a specific amendment or a specific piece in order to get it to the U.S. Supreme Court. Then the U.S. Supreme Court will say, in this case, through the 14th Amendment, we now apply this right within the Bill of Rights to the states. We've not had a 7th Amendment case in front of the U.S. Supreme Court. They have denied cert on all of those cases. So because of that, they've not issued any case law saying the 7th Amendment applies to the states from the 14th Amendment. Therefore, it does not. That's the doctrine. That's called selective incorporation. And it's something that seems to be not very well publicized or taught very well. But it is something that is a fundamental piece of constitutional law. We have to have the U.S. Supreme Court use the 14th Amendment to apply the right to the states, or else it's not incorporated. That's what happened with the 7th Amendment, the 3rd Amendment, the right to a grand jury indictment under the 5th Amendment. It's not been incorporated yet. And again, it wasn't until 2019 that the excessive bail and fines was applied to the states through the 14th Amendment. Yes, it is. Oh, Deanna, it is something that is one of those things that kind of is just not explained or presented very well to a lot of people, but that's exactly what it's called. It's called the Selective Incorporation Doctrine. And it's because we had a case, the U.S. Supreme Court decided years and years ago that said the Bill of Rights only applied to the federal government. So because of that case, we had to go through time after time in order to incorporate things to the states. That's why the Second Amendment did not apply to the states until 2010, when the U.S. Supreme Court decided a case and said, now it does apply to the states. And that would be the McDonald case. Yep. All right, so we've got the 9th Amendment here. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So the 9th Amendment covers any rights that haven't been set out in the Constitution. Doesn't mean you don't have them, just means we didn't write them in the Constitution, and they're still retained by the people. The 10th Amendment sets out any powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. So the 9th Amendment covers rights. The 10th Amendment covers powers. So these are kind of our catch-all phrases here when it comes to the 9th and 10th Amendments. Okay? Yes. And the Supreme Court can change what the amendment means one case by case basis. Yes, they can. Yep. They can do that. All right. So those are our Bill of Rights. Next, we will go, I'll take you through the rest of these amendments. I'm not going to spend too much time on the details of some of these procedural amendments because it's just, we kind of just have to take the time and go through that. But we won't be doing that tonight. But I do want to get into just kind of an overview of some of these procedural amendments and then get into those post-Civil War amendments. Oh, sure. Oh, absolutely. Happy to help in any way. All right. So we've got the 11th Amendment. The 11th Amendment was passed because of a case the U.S. Supreme Court decided called Chisholm versus Georgia. So this is an example of when the U.S. Supreme Court said, this is how the law is, and Congress said, we don't like it, and so they passed this amendment. And this has to do with the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. So this is what kind of changed that language in Article 3 in order to kind of set up jurisdiction for lawsuits in a little bit different manner in response to the Chisholm case. That takes us to the 12th Amendment. This is the amendment that I refer to as the Alexander Hamilton Amendment. It was passed because of the problems that happened with the 1800 election with Thomas Jefferson, Aaron Burr, in the Electoral College. All of that was a nightmare. So June of 1804 is when this was ratified, and I believe it was just a few months later that Alexander Hamilton was killed in the duel. So the 12th Amendment sets out a new process for the Electoral College, trying to clean that up a little bit. It's still a bit of a mess, but that's what the 12th Amendment does. And I'm not going to spend too much time really going through the details of the Electoral College because it's the way that the language is set out here does not make it any clearer just to actually hear it. So I have had multiple posts on the Electoral College, and I will get another post just up on the 12th Amendment going through it, but have to kind of wait for that. So, all right. So here we go. Electoral College under the Alexander Hamilton. Yes, the 12th Amendment. And it went in and it changed the information set out in Article 2 regarding the original Electoral College that was a mess in the election of 1800, that they really just were like, this can't happen again. So this is the amendment that was passed. Yep. All right. Okay, hold on. I think somebody just asked. Let me just skim through this real quick and see. Okay, so let me clarify. Somebody asked about Vice President Pence and his role. So I think I can get that information to you within just the first few sentences here. So the electors shall meet in their respective states, vote by ballot for president or vice president, one of whom at least shall not be an inhabitant of the same state with themselves. That's the same as in Article 2. They shall name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president, and they shall make distinct lists of all persons voted for as president and all persons voted for as vice president, and of the number of votes for each, which lists they shall sign and certify. Here we go. So this is the whole controversy that we've been talking about with regards to the lawsuit or the criminal case. They shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be the president. If such number be the majority of the whole number of electors appointed, and if no person have such majority, then from the persons having the highest numbers, not exceeding 3 on the list, and so on and so on. So this is the piece that sets out the ceremonial role of the president of the Senate, which is the vice president, and what they're supposed to do. Yes, and I've read Executive Order 13848, and so I don't see its relevance at this point. I can do a video on it if you want, but that doesn't really have much to do with what's going on here. Show you the word ceremony. So, when we go through the language in the Constitution, we've got kind of implied and enumerated things. So here they're saying the vice president, okay, so and the number of votes for each, which list they shall sign and certify to transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and the House of Representatives, open all the certificates, and the votes shall then be counted. So, that is explaining specifically what the President of the Senate is supposed to do. And so, a word you could use to describe the actions of the president of the Senate would be part of the ceremony regarding the Electoral College is that we give them to the president of the Senate, and then he opens the certificates in front of the Senate and the House of Representatives. So these words together imply a ceremonial role that's done here. So I think if you're trying to say, well, if the vice president decides to, not open all the certificates or, open a different set of certificates, it can change things. Well, technically, I suppose, because under the Constitution, they're supposed to open all the certificates and the votes shall then be counted. So if for some reason, the person in this ceremonial role does something other than what's described as what he's supposed to do, I suppose you could contest that. But technically, again, this is just one of those formalities, like the exact wording of the oath of the president. If for some reason the oath of the president missed a word and or the, it doesn't mean they're not president anymore. It just means, you missed the word and or the. So that's a ceremonial issue. Right. And that's the thing is there was no contesting. With what's going on with US v. Trump. There was no contesting because the vice president said like 50 times, there's no contesting. Even right before he went into the ceremony, he's like, there's no contesting. I'm going to go in, open the certificates, count the votes, we're done. And those were his own words. Yeah, I don't really know. Oh, it doesn't bother me whatsoever if views are going down. Nope, not one single bit. I can understand if people want to move along and aren't interested. That doesn't bother me at all. Yep. No, they didn't. They didn't contest it, Jacob. Jacob, they didn't contest it, and that's written out into the indictment. Those states specifically, including their governors and all of their courts, said that they did not contest it. Nope. Oh, sure. Yeah. Oh, I'm not here for views. I'm just here to explain things. No, they didn't. They really didn't contest it. I get it. I hear what you're saying. And that's because the rhetoric at the time was so convincing. But just read the indictment. And then if you don't believe me, call up the majority leaders of the governments of those states. Call the governor, look up the court cases. I mean, that's just evidence of the court saying there's nothing wrong with the state of Michigan. There's nothing wrong with New Mexico. Everything in Georgia was great. The governor of Pennsylvania is like, all of our votes are great. There's nothing missing. Ask the governor, ask the courts. I mean, they're in each one of those states that was involved. I mean, Wisconsin's like, what are you even talking about? The Wisconsin Supreme Court's like, what are you talking about? So no, it's not. Nope, they weren't. And you may have seen something. I don't know what it was, but it wasn't that. So, No, I'm not relying on allegations of facts. I'm relying on court documents. I'm looking at court documents. That's what I'm looking at. And I encourage other people to as well. I mean, you don't have to take my word for it. You certainly don't have to take my word for it. Just look at the court cases. I think there were over 60 court cases regarding questions of the voting, and you just look at the cases. Just read the cases. All right, here we go. Now we've got the post-Civil War amendments. These were a batch of 3, the 13th, 14th, and 15th. These had to be signed by the southern states in order to come back into the Union. Until they signed it, the southern states were under military control by the North. So we've got the first piece, which is the 13th Amendment. Section 1, neither slavery nor involuntary servitude except as a punishment. That's what we call the, this is the exception here. I think a lot of people may not know this, but we actually do allow for slavery or involuntary servitude in situations where it's a punishment for a crime, where the party shall have been duly convicted. So it is allowed, and several states still do allow for slavery or indentured servitude for prisoners. And that is something that's very controversial. Many states have closed what we call this kind of a loophole within the 13th Amendment that doesn't allow it, but many states still do. So just so you know, slavery is not allowed except as punishment for a crime, and shall exist within the United States or any place subject to their jurisdiction. Congress shall have the power to enforce this article by appropriate legislation. As a quick side note, this is the only amendment. Yes, it does, Sharon. There's been a huge movement to close the loophole on this. But this is the only amendment that was actually signed by a president. President Lincoln signed this amendment. It was that important to him. And there were some questions about whether or not he actually had the authority to sign the amendment. None of the other amendments had been signed by the president. But by the time the question got to Congress, and Congress was like, I'm not sure if the president should be able to sign that, he had been assassinated. So we just kind of left it as it was. And then we've got the 14th Amendment, which really changed the course of the country. Oh goodness. Seditious media for President Lincoln? Oh my goodness. Okay. Good enough. So the 14th Amendment, Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law that shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. This is the due process clause that applies to the states, nor deny to any person within its jurisdiction the equal protection of the laws. And this is the equal protection clause of the 14th Amendment. So the equal protection laws set out civil rights. The Bill of Rights are those kinds of civil liberties, but civil rights actually came because of this phrase, equal protection of the laws. So that is a significant piece when it comes to the 14th Amendment. Section 2, representatives shall be apportioned among the several states according to their respective numbers. Counting the whole number of persons in each state. Of course, we needed to clean that mess up because we weren't counting whole peoples. So that was included in this language, excluding Indians not taxed. So again, this had to kind of be cleaned up after the war. But when the right to vote at any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officers of the state, or the members of the legislature thereof, is denied to any of the male inhabitants of each state being 21 years of age. All right, so this is the right to vote if you are a male and you are 21 years and older. So this is the first voting amendment in the Constitution right here, okay? And citizens of the United States or in any way abridged except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the member of such male citizen shall bear to the whole number of the male citizens 21 years of age in such state. So again, we're dealing with this, how do we count people after the Civil War? Section 3, no person shall be a senator or representative in Congress or elector of president or vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid and comfort to the enemies thereof. But Congress may vote of 2/3 of each house to remove such a disability. So this is that section of the 14th Amendment that says if you've taken an oath and you are involved in an insurrection, you may not be put back into a position where you need to have that oath done again. So you can't hold an elected position. Section 4, and this is the validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. Now, I'm not going to read this entire piece, but this is the one that was talking about the debt ceiling. So if you're wondering where that language came from, it came from this piece. And then, of course, we've got this last piece that says Congress shall have the power to enforce by appropriate legislation. And that takes us into the 15th Amendment. The 15th Amendment is the right of the citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. So this allowed anyone to be able to vote no matter the race. That's the 15th Amendment. The 16th Amendment, the Congress shall have the power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. This cleaned up Article 1, Section 9 of the issue. Right, or previous condition of servitude. So that was if you were an indentured servant or if you were a slave, is what they're saying here. That's exactly how that language translates. All right, so we've got 16th, income tax, the 17th Amendment. Again, we had some issues again in Article 1, Section 3 regarding the election of senators. So shall be comprised of 2 senators from each state elected by the people thereof. So this amendment changed the process of the states' legislatures voting for senators and gave the right back to the people to vote for the senators here, and then also vacancies and so on. So back up into Amendment 18. This is our Prohibition Amendment. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within the importation thereof into or the exportation thereof from the United States and all territories subjects to the jurisdiction thereof for beverage purposes is hereby prohibited. This, of course, did not have the response that people had wanted. It was completely unenforceable. So we came back with the 20th Amendment and repealed the 18th. But the 18th is that Prohibition Amendment. After the 18th came the 19th Amendment. This was passed June of 1919. The right of the citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. This is what allowed women to vote. So here's our next one. So far we've had 3 voting amendments. We've got the 14th, so you have to be 20. The 15th, it doesn't matter what your race is, or you have to be 21, for the 14th. It doesn't matter what your race for the 15th. For the 19th, it doesn't matter if you are a woman. The 20th Amendment, this clarified some of the issues that we had regarding the presidential terms. Now, this was passed in 1932. It ratified in 1933. We, of course, had a president who had been elected more than 2 times, had been elected repeatedly, and that was very frustrating to people. George Washington set the trend with 2 terms, but this particular president just kept going. So they put in here, the terms of the president and the vice president shall end at noon on the 20th day of January, and the terms of the senators and representatives at noon on the 3rd day. So we changed that day so we don't have that lame duck period anymore. And that's what we're setting out within the 20th Amendment. So instead of having that long lame duck period when all kinds of things can happen, we changed this up to the 3rd day of January. Yes. Let me just make sure I've got this language correctly done here. Sometimes I do get things a little bit mixed up as I go through my lecture. So let me just double fact check here. Okay. If at the time fixed for a beginning of the term or of the president-elect shall have died, the vice president-elect shall become president. If a president shall not have been chosen before the time fixed for the beginning of his term, or if the president-elect shall have failed to qualify, then the vice president-elect shall act as president until a president shall have qualified. And the Congress may by law provide for the case wherein neither a president-elect nor a vice president shall have qualified, declaring who shall then act as president. So let me take a step back and just say, so this is the order that we're going into for that. And we've got what will happen if there's a case of death of any of the persons from whom the House of Representatives may choose. And then we're ratified by 3/4 of the state. I'm pausing here because I think I just want to make sure. Okay. So the 20th Amendment, let me take a step back here. It's getting late. My brain's a bit fried. Yep. You're right. The 20th Amendment, my bad. Hold on. The 20th Amendment changed the date to the 3rd of January. Okay. And again, we are dealing with this 1933 piece. So we are dealing with what happens when a president passes. But the 21st Amendment, which repealed prohibition, occurred next. And then it wasn't until the 22nd Amendment where we have the two terms requirement. So the 20th changed the dates here as well as succession. The 22nd, which was passed in 1951, this is the one that set the two terms. Okay, so let me just clarify that. We've got the 20th and the 22nd Amendment. In between is the Prohibition Amendment. Okay? Oh, sure. Yep. Term limits. Yes, that's a great question. All right, so the 22nd Amendment came in and said you can only run twice. I did misspeak. I get the 20th and the 22nd mixed up a little bit. It's hard to remember all 27 amendments. I'll be the first to say it. All right, so let's go into the 23rd Amendment. This was passed by Congress in 1960, ratified in 1961. The district constituting the seat of the government of the United States shall appoint in such manner as Congress may direct a number of electors of the president and vice president. The 23rd Amendment gave Washington, D.C. the power to have a certain number of electors for president or vice president. Now, there had been several amendments passed to make Washington, D.C. a state, but it was never ratified. We did not have enough states agree in order to ratify it. So this was kind of an attempt to give some voice to the people living in D.C. in the form of being able to vote for certain electors when it came to the president or vice president. So that's the 23rd. Now, the 24th was ratified in 1964. This is another voting amendment. The right of citizens in the United States to vote in any primary or other election for president or vice president, for electors for president or vice president, or for senator or representatives in Congress shall not be denied or abridged by the United States or any state by reason of failure to pay poll tax or any or other tax. This is our poll tax amendment. Of course, this was in a direct response to the issues that were going on, particularly in the South, although throughout all of the United States, where they were saying you have to pay a certain amount of money in a tax form in order to vote. This was unacceptable, and an amendment was passed to do away with the requirement of poll taxes. So that is the 24th Amendment. That takes us then to the 25th Amendment, which was ratified in 1967. And this is in case of removal of the president from office or his death or resignation, the vice president shall become president. So we did have with that 20th Amendment some discussion of succession of what happened, but it was still a mess. And this particular amendment, the 25th Amendment, was passed because of what happened with President Kennedy. And because his vice president was sworn in on the plane, and there were all these kinds of questions that happened, and we had just lost a couple of presidents previously, they're like, look, we need to get this sorted out. So this is where the true succession really came into play, is with the 25th Amendment. And they walk through who's in charge, what happens if the president passes, what happens if the vice president can't do it, who's up next. So the order of succession then is set out within the 25th Amendment. Okay, so then we go to the 26th Amendment, ratified in July of 1971. There was a lot going on in the U.S. at the time. The right of the citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state on account of age. So our voting age was changed to 18. This is our last voting amendment. So as you can see, the right to vote has the most number of amendments of any right within the Constitution. That was the response, of course, directly to the draft and various things that were going on at the time. If you're old enough to be drafted, you should be old enough to vote. The age was changed to 18. Now, this takes us then to the 27th Amendment, which was passed in 1992. This was one of the original proposed Bill of Rights that did not get passed by the original Congress. So we brought it back in the 90s. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. So this is all about the timing of when Congress can give itself a raise. This was originally written by James Madison. It just didn't make it past the cutting room floor with the Bill of Rights. And eventually there's a huge push for it in the 90s, and it was ratified by the states in 1992. So that is the 27th Amendment. That is all of our amendments. The super quick version of that, of how our amendments are set out. They get paid too much as it is. It seems like it, doesn't it? It does seem like it sometimes. People think it's the same as Republican Democrats. Nope. No, I think there's a lot of language questions, and there's great questions to ask. But yeah, we had a lot of differing views when it came to party names. But treason is set out in Article 3 of the Constitution, and it's very, very broad. It's madness in the chat. Oh my goodness. Oh no, not the madness. Not the madness. Yes. Thank you for hanging out with me. I appreciate you all hanging out with me, even though we had a little little sidebar there briefly. But any new court files? I don't know. Let me check. This court case has moved along so quick. I'm just like, what's happening? But I hope that was helpful for people. Again, the articles really are what created, all the branches of the government and all the proceedings that we need to have and so on. So all of those things were set out, and then our amendments came much later. So, which was very, very good. And it was very controversial at the time. A lot of people wanted the Bill of Rights to be attached to those articles, but they just felt they wouldn't be able to get it ratified. I think they were probably right. I think it would have been hard to get it ratified at that point because it was so controversial. And again, I mean, this Constitution was in direct response to the Articles of Confederation, which were not working at all. So, yes, you're welcome. You're welcome. I'm hoping this was helpful or interesting to people in some way. Hopefully, you've gained a little bit of insight into what we've got going on here. So you can kind of take that with you and decide how you feel about it. Yes, David, I started the evening out. I started about 7:00, and we went word by word through all of the articles. So we're just at the point in the live here where I'm getting through the amendments for all of these amazing people that have stayed with me and have been interested to hear it. Oh, sure, no problem. I have a Tube of You channel, and what I do, because my lives tend to go so long, I think I just chat too much, but I do upload my lives for anyone who just came halfway in or only want to hear certain pieces of it. I do put them up on the Tube of You. It's the same name as my TikTok name. And you can kind of listen to the full live and, fast forward and whatever to kind of make it a little bit easier for people. So, yes, I will have this posted. I've got another one I need to get posted as well. It takes a little time for everything to get uploaded, but I do put my lives up on my Tube of You channel for anyone who's interested. So, yes, I pulled up the docket. There hasn't been any additions since I started the amendments. Oh, thank goodness. Yes, the court filings. Nothing new's been added so far. Fingers crossed. Yes, the Tube of You. I have to be careful for my TikTok algorithm here. So how do I find you live on? Well, I don't go live on the Tube of You. I just kind of go live here on the TikTok. And I try to give out a warning. I try to give out a notice of what the topic is. Sometimes it just seems the last few days, there have just been a lot of last minute additions to a few pretty big cases. So I've kind of been hopping on to explain those documents. But typically what I try to do is I try to come and go through a particular constitutional law issue, and we just kind of talk about it for a while and so on. So I'm trying to get back into my regular content. Oh, thank you. Thank you for subscribing. I appreciate that. Oh, from now on. Oh, that's funny. Oh, sure. Oh, this is just fun for me. I love talking about the Constitution and different fun issues like that with people, and it's great to have good debates and conversations back and forth, and kind of get things cleared up and sorted out. Um, oh, okay, okay. A journalist first edition. Well, that's interesting. Let me make a note of that. Um, Let me just make a note. That's something I've not heard of before, and I love to get new information. So I will look into that. It's 7 p.m. Oh my gosh. Oh, Lewis. Oh my gosh. You're just a champion here. Oh, the Thanos ring. Yes, I change my rings up a little bit as I go. Oh my gosh. Yes, I try. Can a lawyer be federally licensed if he does not pick a state? I don't know. Clark. That's a good question. I can practice in federal court, but I need special permission. I'm not licensed to practice there all the time, but I am licensed in my state, and they do ask you for your license in order to request being able to go into federal court. So I'm assuming you would have to be licensed in some jurisdiction somewhere. Some people just go and do DC, which is really transferable. So a lot of our federal people are licensed out of DC, and then they can go federal at that point. So yes, well, I like to, oh, thank you. Well, I mean, I don't know. It's good to, kind of figure things out. And is there a difference between an attorney and a lawyer? I think it's a preference thing. A lot of people say that lawyers are the ones that, are kind of in the trenches and going into court and arguing, versus an attorney, which is more of an academic point of view. And some people say lawyers are not licensed and attorneys are licensed. So I think it really is dependent on where you're at in the U.S. There, we kind of throw those terms around a little bit different. Or Esquire, yep. ESQ is what you can put behind your name after you graduate law school, but or JD because it's a doctorate. But to actually be an attorney at law, you need to be licensed. Yeah, you need to be licensed. So in some places they say that it's only attorneys, but some places say that it's lawyers. So I think it depends jurisdictionally, what they like to do. How they like to do it. You kind of get a feel for that when you go into whatever jurisdiction you're in. Like, okay, everybody calls, what do they call themselves? And so we chat about it that way. But I remember all of us that were getting ready to graduate from law school, but we hadn't been licensed yet. We hadn't taken the exam. We hadn't been licensed. And so we're all like, oh, we're Esquires. And so people would write Esquire, whenever they were signing something. It's like, oh, we want to be cool. It's like, no, I'm not sure. I don't think people like lawyer too much. Well, I think you may be right. I think you may be right. Oh, yes. And that's understandable. That's absolutely understandable. You look kind of young. Oh, thanks. Yes, I try to remain a little bit mysterious. I get the JD to use Esquire. That's an expensive addition of those three letters. But for any which way you want to go for you. Yes, I do. An attorney is an employee of the government. Can be. I don't think you have to be, though. I mean, we can have our own practice in our own law firms. We don't work for the government. If we are a prosecutor, we work for the government, or if we're in any of those kinds of specialty roles. But most of us don't work for the government. There's not that many government positions. So how can I hire you? Well, I don't take any work through TikTok. I have kind of my own world going on outside of TikTok. So I really don't take on any clients through TikTok. So, but I'm just here to educate. I'm here to kind of clear things up and answer questions for people. So, okay, I got you. Interesting. Do I have a specialty? I really don't. I teach. I've focused my teaching on criminal law, constitutional law, criminal procedure, evidence, civil litigation, those kinds of things. So that's really where my teaching area has been. But What's my Venmo for donations? Oh, I don't take any donations. Oh, but thank you. Oh, how kind of you to even ask that. But no, nope, I don't do any of that here. I'm just here to kind of make things open, get access easier for people to this kind of information for anyone who's interested. So criminal and civil. Yep. I do a little bit of everything. I spent a lot of time in both worlds. I really concentrated in a particular area, then moved on. So that's kind of been my what I like to do. When would you do immigration law? Well, it's on my list. I've got a list. I've had some things that have kind of put me off of my regularly scheduled content, but I do have a list. Oh, thank you. Can you fund a pro bono on the side to help the underserved? I choose to, rather than put money into that, because I'm not really sure how that money is going to be utilized. I tend to offer services. So I do a lot of pro bono work in my community, and I get a lot of people referred to me. So I choose to offer my time and energy as opposed to money, because that way I can make sure I know that they're getting the most out of what I can offer. So still can't vote. It is expensive. It's very expensive. It's very difficult too. Those tests are tough. Yes, I think it's important. Hopefully people can find it helpful. I absolutely hope it's of some interest to people. I'm so thankful for anyone that can stop by and ask questions and is interested in it. I am in the central time zone in the United States. I don't give out any more specific information than that. I just I've had some problems in the past, but I'm in the central time zone. Serious question: is finding a pro bono a thing? It's a contradiction of terms. Is finding a pro bono a thing? Funding? I think it depends on where you're at. We do a lot of good pro bono work in my particular jurisdiction, but again, you have to be, the people that kind of set all of that up and process all of that. I prefer to kind of do it myself. I think it's that way I know that everything is going the way that I think it should go. I guess maybe I'm a control freak, but rather than going through the regular avenues that most people go through, I kind of like to I'm more of a grassroots way of looking at it. Yeah. They usually just find me. That's how it works in my world, is that usually it's word of mouth and people come to me and I talk with them. Have a good night. Oh, yes, you have a great night too. Thank you for coming. I appreciate that. I do appreciate that. Hopefully you'll be able to come by later. Oh, thank you. Thank you very much. So kind, so very kind. Oh, yes. And again, thank you so much for stopping by, everyone. I will probably actually myself go ahead and wrap up. I think it's been 3.5 hours now that I've been going with so many wonderful people coming and joining me on these lives. I'm so thankful for that. So I will go ahead and hop off now. And when I set up my next lecture, I may need to take a break. My voice is getting a little, but I will post what the next topic will be at some point. So I will have to, yes, Cody. Oh my gosh, I know. I don't know how people, hopefully people just kind of go away and come back and go away and come back and not hang out the whole time. I can't even imagine staying with me the whole time, but yes. Thank you so much, everyone, for swinging by. And I will be back again. We'll be back to try to, share as much information as I can, and make sure, of course, to tag me in anything that you've got questions or concerns about. I'm always happy to look into anything people are tagging me on. So, all right. Well, everyone, have a fantastic night. A happy weekend to everyone, and take care. Thanks again for being with me.